go straight to submissions. We're obviously on a tight schedule once again. Good to see you all.
Tēnā koe, Duncan.
Tēnā koe. We can't see you at the moment, but that's okay. If we've only got audio, that's fine. But we've got you for 10 minutes. So if you want to just kick off, and if we've got any questions, say, we might want to leave some time at the end for those, but we've got 10 minutes if you want to kick off. Kia ora.
Kia ora. Tēnā koutou. My name is Tracy Hope. I chair FOMA, the Federation of Māori Authorities. I'm not sure why my camera isn't working. Kia ora. Duncan, can you hear me even though you can't see me?
We can hear you fine. Sometimes this happens, a few technical glitches. But if you want to just kick off, that's absolutely fine. We'll see how we go.
Okay. Tēnā koutou. My name is Tracy Hope. I chair FOMA, the Federation of Māori Authorities. Joining me today is Liz Mellish, FOMA co-chair, our executive committee and our business board. Established over 45 years ago by Sir Hepi Te Hiuhiu, Waka-a-Maui, Alec Wilson and Kahurangi Dame Ingrid Collins and other Māori leaders, FOMA exists to help our members prosper and grow through responsible economic and sustainable environmental development. Our FOMA members include Māori trusts and incorporations, ahu whenua Māori, pre- and post-settlement entities, as well as Māori-owned businesses with assets, investments and interests in the primary industry, agribusiness, commercial property, renewable energy and innovation and technology. Of the 1.5 million hectares of Māori freehold land, FOMA members represent a combined land holding of over 400,000 hectares, making a significant economic contribution to Māori and for Aotearoa New Zealand. Since its establishment, FOMA has worked successfully together with Māori and iwi, government and industry in various partnership arrangements based strongly on the principles of te tiriti or waitangi. This approach has helped foster and promote the development, sound management and economic advancement of our members and other Māori authorities through policy and legislation for the betterment of all Māori and Aotearoa. Today, FOMA brings the Māori primary industry and business to this discussion. FOMA strongly opposes the Treaty Principles Bill and calls on this government to reject it as legislation that threatens the very foundation of our nation's identity, justice, and partnership between Māori and the Crown, and further undermines Māori economic rights and long-standing treaty obligations. We acknowledge all previous submitters who have also opposed this bill and support our learned colleagues who have eloquently articulated the legal, cultural, environmental and societal reasons this bill must be thrown out. The treaty principles have provided a pathway for addressing past injustices and created a more equitable Aotearoa, and this is now a central legal doctrine upheld by our courts, our tribunal, and successive governments. FOMA is deeply disappointed that this bill has even gone to first reading. We call on this government to show the leadership that is necessary on this matter by abandoning the bill which threatens to dismantle decades of progress, negotiated settlements, and good faith partnerships that have contributed to our social and economic advancement for Aotearoa. We can think of other legislation that the government might turn its mind to that hinders economic growth and exports for Māori and Aotearoa. For example, legislation that FOMA and others could work on with government and the Crown, like the Commodity Levies Act, from which Māori see very little value, the Māori Reserve Lands Act, which holds Māori in and administers Māori land with little market return for its owners, or the Public Works Act, which is in a topical discussion now and holds and uses our whenua Māori even today. FOMA supports the submissions of the New Zealand Māori Council, Te Rongahoia, Te Hungaroia Māori o Aotearoa, and concurs with the Waitangi Tribunal's report and recommendations that the Treaty Principles Bill and policy should be abandoned, that the Crown should constitute a Cabinet Māori Crown Relations Committee, not the Social Outcomes Committee, and that has oversight over the Crown's treaty and te tiriti policies, and that this committee should include all Māori, whānau, hapu, iwi, and ahuwhenua, and that FOMA, of course, as always, is prepared, willing and able to work with government and the Crown on this matter. Back to you, Mr. Chair.
Thank you very much for that. Members, we've got some time for questions, if you'd like to. And of course, if any of your other colleagues want to contribute, that's possible as well. I see we've got a question from Scott Willis. Let's go to him first.
Thank you. So I'm really interested in your idea of the Crown constituting a Cabinet Maori Crown Relations Committee to have oversight. Is this also to help repair some of the relations? Do you see it as necessary to build some reconciliation around this bill in particular?
Kia ora, Scott. Thank you for your question. It's a good one. We think that such a committee would be tasked with working together with Māori to, as you mentioned, repair relationships, to explore opportunities with regards to te tiriti o Waitangi, and also how we might work forward on this particular matter.
Mm. Thank you.
Kia ora. I know in some ways that's the remit of Te Arawhiti, right? I'm just wondering how that, if you want to comment on that.
Yeah, kia ora, Duncan. Another great question. Te Arawhiti in particular supports government in relationship to its delivery and remit on Crown Māori relationships as officials. The proposal that the Tribunal puts is that Cabinet would construct a committee tasked for the purposes of discussing the treaty principles, discussing te tiriti o Waitangi, and how we might work forward as partners.
Yeah, okay. Well, kia ora, thank you for that. Members, if there's no more questions, that's great. Thank you very much for that concise submission. And we've got your written submission, which I've had a look at. So thank you very, very much for the submission. Kia ora.
Good.
Tātou.
Okay, you ready?
Members,
Take your stuff off here. Take your things away.
Members, our next submission
So are those socks on the floor?
Tuwharetoa Māori Trust
I'm washing
Board.
shortly.
Kia ora, Maya. Are you submitting for us today?
Yes, tēnā koe te hiamana.
Oh, kia ora.
Mira.
Great. Well, look, I'll hand straight over to you if you like. You've got 10 minutes, including any questions. So, ka pai, all yours.
Tēnā koe. E te hiamana e ngā mema o te komiti whakahaere e tēnei a tongariro maunga e mihi atu ana kia koutou. My name is Maya Wikaida, and I'm here on behalf of the Tuwharetoa Māori Trust Board, together with the Trust Board's Chief Executive, Rachael Taiaroa, to express our strong opposition to the Treaty Principles Bill. The Trust Board has been a long-established entity. It was established pursuant to the Māori Land Amendment Act 1924 and Māori Land Claims Adjustment Act 1926. The Trust Board later became a Māori Trust Board under the Māori Trust Boards Act 1955. We are here reluctantly because we consider that this bill is regressive and a complete waste of time, money and effort. And yet we are here having to explain one of the Trust Board's documented relationships with the Crown to you, to demonstrate to you the complete disregard this bill has had for that relationship, and to reveal the bill for the farce that it is. We take our submission as read, and in the time available, intend to focus on a critical impact of the bill on that relationship. Now, outside of treaty settlement, and I repeat, outside of treaty settlement, by deeds with the Crown in 1992 and in 2007, The Trust Board is the legal owner of the bed, water column and airspace of Lake Taupo, of various tributaries flowing into Lake Taupo and the Waikato River to a landmark known as Te Toka a Tia, the Rock of Tia, inclusive of the Huka Falls. This area is known as Taupo Waters, and the deeds are known as the Taupo Waters Deeds. The Trust Board's relationship to Taupo Waters is unique. It holds legal title as trustee in relation to Taupo Waters, and it holds rangatiratanga and access kaitiaki for Taupo Waters on behalf of Ngati Tuwharetoa. The Trust Board's 1992 deed with the Crown expressly refers to the Treaty of Waitangi. The agreement was made between the Crown and Ngati Tuwharetoa to manage and administer Taupo Waters, and I quote, in accordance with the spirit and intention of the Treaty of Waitangi, as the spirit and intention, are now understood. The deed refers to Lake Taupo being a taonga of Ngati Tuwharetoa and embodying the mana and rangatiratanga of Ngati Tuwharetoa. The 2007 deed further formalised this partnership. Principle 2 of the bill, which proposes to only recognise the rights that Ngati Tuwharetoa had when Te Tiriti was signed, is directly at odds with this 1992 deed text and the rights that were confirmed in respect of those deeds at that time. Further, the additional limitation in Principle 2 that iwi and hapu rights differ from the rights of all New Zealanders only insofar that they are specified in treaty settlements directly undermines these Taupo Waters deeds. Our Taupo Waters deeds are not the product of treaty settlement. They are a clear example of the existence of relationships and the affirmation of iwi rights and interests outside of settlements. They are a recognition that treaty settlements do not contain or address all of the rights and interests of iwi and hapu that are guaranteed in Article 2 of Te Tiriti. Principle 2 is therefore a fundamental breach, in bad faith, of the intended approach to the Taupo Waters deeds between the Trust Board and the Crown, and it has impacted the long-standing and otherwise positive relationship between the Trust Board and the Crown. The Bill's principles dismiss these and other Ngati Tuwharetoa enduring rights and responsibilities. We point this out not to suggest that an amendment to add reference to these deeds will fix this matter, but to show just how misguided and misinformed the development of this bill has been. For the full reasons that have been identified in our written submission, the bill in its entirety is unconscionable, and we ask that the bill is abandoned. Thank you, Mr. Chair.
Kia ora, thank you for that. And we've got your submission, which is, I must say, really, really well written. We've got time for questions, members. One of the questions I had, if I may, is, and it's in your submission, you talk about being kaitiaki of the river and other parts of the natural environment. And I guess a lot of the discussion so far has been on kind of the rights conferred by the treaty and how that plays out. And I guess it's one way to look at it, but your submission sort of touches on some of the relationships and responsibilities that you see as yours to discharge. What would this bill do to that relationship?
Thank you, sir. I'd also like to acknowledge the presence of Peter Shepherd, who's joined Mr. Rachael for Aotearoa, and I'll answer, and then if either of they would also like to answer, but thank you for your question. That's exactly right. So from a tikanga perspective, of course, there are two sides to the patu, one might say. There are the rights and then there are inherent obligations and responsibilities. And for the Tuwharetoa Māori Trust Board, the issue here is that while the deeds will continue to exist, where treaty principles otherwise refer to where treaty principles clauses are otherwise included in other legislation, so the Local Government Act, Resource Management Act, and etc., Conservation Act, then the obligations that the Trust Board holds to protect Taupo Waters, not just as legal title owner, but in terms of its rangatiratanga and its role as kaitiaki, will be impinged because they will not be identified as obligations that reasonably differ from the rights of all New Zealanders or the obligations of all New Zealanders otherwise in the context of that other legislation. And so the obligations which then turn on how one might expect in order to satisfy those obligations, one might fulfill, for example, consent conditions in respect of major applications. And when you reflect on, for example, the large consented activity in and around Lake Taupo, or along the Waikato River, then those matters won't be taken into account and won't be considered in the context of a trust board's critical obligations on behalf of the iwi.
Kia ora, thank you for that. Did your colleagues want to comment?
No, thank you very much.
No? Okay. Members, any other questions? Scott Willis.
Thank you, and again, really comprehensive submission. I really appreciate it, and it sounds as though yours there's a real challenge here in maintaining or protecting nature for the sake not just of the trust but also for all of us. So is the argument here that we need to respect Te Tiriti as it is, to ensure that we manage our resources and that those who have responsibility manage them on our behalf appropriately.
Yes, thank you, committee member. Thank you for your question. That's exactly right. Te Tiriti o Waitangi doesn't have unilateral rights and obligations in respect of Māori only, or doesn't recognise those or the full expression of those only. It is a document for all New Zealanders. It is a document that supports Māori obligations that it has towards te taiao, the environment, and it has towards its iwi. And of course, the full expression of those will satisfy obligations that better support the interests of all New Zealanders. The Taupō Waters deeds are a prime example of that. So one of the issues that are found or enshrined within the Taupō Waters deeds is recognition that not only is Lake Taupo a taonga to Ngati Tuwharetoa, but it's also a place of great significance to all New Zealanders for its recreational and other values. And so part of the Taupō Waters deeds was recognising that and enshrining the recognition of access for all New Zealanders for those recreational opportunities. So the Te Tiriti can be a foundation for partnership for all of Aotearoa.
Kia ora, kia ora Maya, thank you for that. Look, yes, kia ora, do go ahead.
Kia ora, Rachael Poho Taiaro, CEO Tuwharetoa Māori Trust Board. I suppose just to put a structural understanding with regard to the 2007 agreement, 992 agreement, especially 2007, there was a party to be created and has done so over the years called the Tauponui Aotea Management Board. Now that board is a board of 4 Tuwharetoa Māori Trust Board representatives and 4 Crown representatives put in place by the Department of Conservation or the Minister of Conservation. Yeah. So that board there has the ethic of taiao, which is our environmental ethics, and as well as non-commercial use of Lake Taupo. So one instance, and I just want to sort of bring it to a practical position, recently we, through the Waikato River, had quite a scare, I suppose, with gold clams. So we worked very closely with BNZ, realising BNZ's budget did not extend to the place where we would like, because there's obviously a number of concentrations in terms of levels, bird incursions down South Island, as well as the flying insects that are in Auckland at the moment. We realise that there is some other priorities to the GDP of this country. So what we've put in place as ourselves is taking over the eDNA testing of Lake Taupo with the help of BNZ. So BNZ assists us in terms of the program and also the assets, and we do the lead work as well as design the eDNA testing. So we're pragmatists here as well. We realise the Crown doesn't have a overflowing resource bucket, and so because of our ethics in taiao, etc., we've certainly in the last 6 months invested around about $250,000 of our own money into this type of incursion, or supposed incursion.
Yeah, kia ora, thank you for that. That's really helpful background. So thanks very much for that. Well, I think we're pretty much out of time, but thanks for your very comprehensive and thoughtful written submission as well. It's really useful. So, kia ora.
Thank you very much.
Members, the next submitter is the New Zealand Council of Trade Unions.
Morena.
Kia ora. Good to see you. You'll be familiar with the process and the limited time we have. We have 10 minutes, including time for questions. So I'll just hand it straight over to you for your submission.
Kia ora, thank you, Chair. Call Richard Wax Apaho. I'm the President of Te Kawa the Council of Trade Unions. And the team here from CTU is Loris Park to my right, is a Runanga co-convener, Erin Palachuk to my left, the Acting Secretary for the CTU, and Guy Aramangoa, our Legal Officer. I'll hand over to Loris to begin our submissions, please.
Tēnā tātou. Ko mata whaura te maunga o Aotearoa, ko Ngati piki a te iwi. I whānau au hau I reira. Engari tōku māma no Ngātirangi me te whānau apanui, tōku pāpā no te hiku tū o te hokianga, ko Loris Parker hau. Tēnā tātou, Raurangatira mā. A great place to start, Raurangatira mā. Tino rangatiratanga is Māori control over Māori lives with the purpose of improving the collective well-being of iwi, hapu and whānau. Absolute sovereignty, independence and autonomy. That's what our tipuna signed for in 1840. The objective of colonisation is to relegate the colonised peoples to subservience by inhibiting cultural cohesion and destroying their language. So the destruction of indigenous languages as a blueprint of colonisation happened all over the world. And in the case of Aotearoa, te reo Māori had almost disappeared in one generation. In 1862, the school inspectorate reported to Parliament that a refined education or high mental culture would be inappropriate for Māori because they are better suited by nature to make their living by manual, not mental labour. In 1880, Te Aute College was led by John Thornton, where the first Māori graduates, including Sir Peter Buck, Sir Apira Ngata, Sir James Carroll and Sir Maui Pomare were produced. But a Royal Commission of Inquiry put John Thornton and his board on trial for continuing to teach academic subjects to Māori boys. John Thornton and his board were sacked. In the 1930s, the New Zealand Federation of Teachers attempted to have Te Reo Māori included in the national curriculum, but this was blocked by the Director of Education, who said education should lead the Māori lad to be a good farmer and the Māori girl a good farmer's wife. By the end of the 1980s, the education system had done what was intended. Māori were well represented on the lower echelons of society, and Māori whānau could now be blamed for not being ambitious enough for their children. Right now, removing words like kura for school, ingoa Māori for government departments is having the same intent as in the colonial days. To destroy the value of te reo Māori, weaken obligations under te tiriti o Waitangi, and to portray Māori as privileged simply because we're Māori. Kia ora.
Kia ora, Loris. I'd like to just make some comments about this bill in regards to individual and collective rights. The principles of Te Treaty of Waitangi Bill were conceived by people who really have no understanding or support for collective rights. ACT and their ilk struggle to accept the notion of community or society and are committed only to advancing individual rights above all else, even if in practice this means growing inequality and threatening social cohesion. Like Māori, the trade union movement understands that none of us are here on our own and that we are all part of something bigger than the sum of our individual parts. And that sometimes stands as, and that's something that stands as a foundation to our individual rights and responsibilities. Māori have a strong understanding of collective rights and collective action. And in fact, Māori join unions, collective organisations of workers, in greater numbers than non-Māori. Te treaty is, in a sense, a collective agreement between the Crown and Maori and must be honoured. I'll hand to you, Kyle.
The ACT Party has often spoken about restoring dignity to landlords. And what this means is that the property rights and privileges of the wealthiest in the community must not be disturbed, while the rights and privileges and entitlements of ordinary people are disposable. For people who value the dignity of the rich and powerful over the collective dignity of ordinary people, Te Tiriti o Waitangi is a deeply inconvenient document. But as outlined in our written submission, it stands. And notwithstanding attempts at neoliberal revision, it expresses a plain desire on the part of the tupuna who signed to secure equal partnership and preserve their collective rights. This bill has nothing whatsoever to do with equality. Maori suffer the real consequences of structural inequality that stem from breaches of Te Tiriti. And when representatives of landlords and bosses call attempts at rectifying these breaches race-based privileges, it is not only morally bereft, it shows the fragility of the powerful who are coddled by the policies of this government. Te Tiriti codes collective power and community rights into the constitutional fabric of Aotearoa. The motivation that has led this government to attack the collective rights of unionized workers is the same as what leads it to attack Te Tiriti. In his speech to this committee, Mr. Seymour stated that even if this bill fails to pass into law, he will not stop pressing its passage. And to Mr. Seymour, we say the workers' movement hears you, we believe you, and you are not the first to push these kinds of agendas. And to paraphrase a great rangatira who stood against past attacks, we say to him, my friend, the workers' movement will oppose you forever and ever and ever. Thank you.
Thank you, Chair. That brings our submission to a close.
Thank you. Thanks for leaving a little bit of time for questions. Members, any questions from other members? Scott.
Thank you, Richard, and everyone. Really, really comprehensive submission. I really appreciate it. And could I ask, for the sake of cohesion in Aotearoa, what positive steps should this or any future governments take in upholding Te Tiriti?
We certainly wouldn't start with dishonouring it by this process. There needs to be, it seems to me that while our past is checkered, we've taken it, this process of this current bill has taken us absolutely in the wrong direction. And we need a government that honours its foundations, honours the foundations of this country, and brings back a sense of priority and foundation of Te Tiriti. You want to make any further comment?
There's also the possibility too, Scott, that any of the discussion needs Māori at the table, Māori to have a real part in the discussion that happens, because as the hiko showed us, we certainly have a lot to say.
Can I follow up the further question, particularly in terms of the work that you do? My question is basically, in terms of the existence of the treaty and its context, history, principles, what influence does that have on the work that you do in trying to enhance the position of workers? It's a bit philosophical, but
I guess we could all say that we're dealing with the same system of oppression.
Yeah.
So we're dealing with a system which has put a lot of workers in a really unenviable position right now, and there are a lot of Maori workers who are in that category. So the union movement is attempting to lift everybody.
And just to be clear, we know that conditions of work, unemployment, workers' issues disproportionately affect Maori workers in terms of the negative impacts of health and safety, unemployment, low wages, insecurity at work, and so forth. So our mission to lift working people's conditions of work and quality of life at work is particularly relevant for Maori, and Maori are particularly relevant to unions as have a strong sense of collective action, collective understanding, and a real source of strength for the union movement.
If I can just add to that, if you look at the history of the workers' movement, it is intrinsically intertwined with the struggle for tino rangakiretanga. You cannot separate the two in Aotearoa. It's one and the same. And workers of Aotearoa have benefited greatly from the collective rights that Te Tiriti enshrines. So I think you cannot understate that connection.
Kia ora. That's really, really helpful. Thanks, and thanks for all the work that you do and for your excellent submission as well. That's pretty much the time we have, so we'll leave it there. But thanks again for your submission. Ka kite. The next submitter members is Hapu or Ngati Porou. And I think we have Agnes Walker submitting for Ngati Porou.
Sorry, somebody in my neighbourhood just decided to start a lawnmower.
I know the feeling. Kia ora, Agnes. Welcome along. I understand you're submitting for Hapu or Ngati Porou.
Yes.
And you've got 10 minutes to do that. So in the interest of time, I'll just hand straight over to you. Kia ora.
Okay. Kia ora. I've got Tina Baker, who's the project administrator for Ngā Hapu o Ngāti Porou, alongside myself as the project manager. I'm making a submission on behalf of the 6 management arrangements representing 48 hapu, which were established under the Ngā Rohe Moana o Ngā Hapu o Ngāti Porou Act 2019 in support of our written submission. We oppose the bill in its entirety, and we wanted to take this opportunity to reiterate our unique position as hapu who entered into direct negotiations with the Crown in 2003. These negotiations resulted in the Deed 2008, Deed to Amend 2017, which was given legal effect by the Ngā Rohe Moana o Ngā Hapu o Ngāti Porou Act 2019. These legislative arrangements contain significant Crown acknowledgements of our rights and interests and provide legal recognition of the role and obligations of Ngā Hapu o Ngāti Porou in the governance and management of Ngā Rohe Moana o Ngā Hapu o Ngāti Porou. This is not a treaty settlement under the Treaty of Waitangi Act 1975. One of the key acknowledgements by the Crown in our legislation is that the mana of Ngā Hapu o Ngāti Porou in relation to Aotearoa Moana is unbroken, inalienable and enduring, and held and exercised by Ngā Hapu o Ngāti Porou as a collective right. We believe this is an unprecedented legislative recognition on the part of the Crown of the legal rights of hapu versus the rights of individuals. If this bill were passed, we would expect the Crown to ensure they can continue to provide legal recognition of our collective rights as per our legislation and not be usurped by the ideology of Principle 3, where everyone is equal before the law and is entitled to the equal protection and equal benefit of the law without discrimination. Everyone is entitled to the equal enjoyment of the same fundamental human rights without discrimination. In our opinion, this principle shows a total lack of understanding of collective rights, which is a fundamental construct of our world and our legislation, especially when read in conjunction with Principle 2, where the Crown recognises the rights that hapu and iwi had when they signed the treaty. The Crown will respect and protect those rights. Those rights differ from the rights everyone has a reasonable expectation to enjoy only when they are specified in treaty settlements. As stated earlier, the Ngā Rohe Moana o Ngā Hapu o Ngāti Porou Act is not a treaty settlement, therefore would not be provided for under Principle 2. In fact, it's worth reiterating that the Crown recognises that Ngā Hapu o Ngāti Porou continue to assert that they have ongoing and enduring ownership interests unbroken by the Foreshore and Seabed Act or the Marine and Coastal Area Act. And it was this belief which was expressed by many of our elders that led to our legislation. We will end on Principle 1. The Government of New Zealand has full power to govern and Parliament has full power to make laws. They do so in the best interest of everyone in accordance with the rule of law and the maintenance of a free and democratic society. While we acknowledge the government has power to govern and Parliament has power to make full laws, the irony is not lost on us on how the ideology of one group of people presumes the right to define what is in the best interest of everyone else, especially with their treaty partner of 185 years. How can we have faith in the Crown when we have heard a number of submitters, including Geoffrey Palmer, a former politician and Prime Minister, who was responsible for considerable reforms of the country's legal and constitutional framework, make reference to the bill's introduction as fundamentally flawed, along with the Waitangi Tribunal stating the Crown's process to develop the bill has purposefully excluded any consultation with Māori, breaching good faith obligations and the Crown's duty to actively protect Māori rights and interests. One of the underlying principles in our Act is Toitu Te Tiriti o Waitangi, Treaty of Waitangi. Consistent with the principle, the partnership principle underlying Te Tiriti o Waitangi, the Treaty of Waitangi, we, ngā Hapu o Ngāti Porou and the Crown, both entered into our legislation as equals with a commitment to act in good faith, fairly, reasonably and honourably towards each other. In concluding, like any other legislative reform in this country, we expect the Crown to uphold our legal rights and interests in Aotearoa Moana as legislated for under the Aotearoa Moana o Ngā Hapu o Ngāti Porou Act 2019. Thank you.
Kia ora, thank you for that, and thanks for leaving some time for questions. We do have your submission here, and thank you for that. It was an interesting read, actually. Members, are there any questions? Scott.
Yes, thank you. I'd like to reiterate Duncan's comment. It's a fascinating submission. I really appreciate it, Agnes. And it seems to me that what we're seeing is an ideological attempt or a free market attempt to remove all collective protections of nature and for future generations. Is this what is, you know, in your submission that you see as a real risk?
Oh, absolutely. You know, fundamentally, that's exactly what is going to happen if this bill proceeds.
Yeah, Kia ora, thank you for that. Yeah, and you're echoing the sentiments of a number of other submitters,
yes,
including former prime ministers. Thank you for that.
Kia ora, thank you very much.
Members, the next submitter is Hayden Turoa.
Me.
Kia ora tātou.
Kia ora, Hayden. Can't see you there yet, but I can hear you.
No, I don't think my video is working, and even unmuting it was a bit of a challenge. So sorry about that.
Okay, that's all good. We can absolutely hear you. So we've set aside 10 minutes to hear from you. So if you wanted to speak to your submission, and if we've got questions, leave some time for those later.
Ka pai. Thank you. Awa angiangi ki te akaru, angiangi ki te māua ke tōku ahotangi wiwini, tōku ahotangi wawana, tōku aho kairi a kāmate. Tu mai ana te whatu manoa mai hoki te whatu whiwhi e te whatu rawi au nei ka whai atu I te moana kauenga waka nene a Maui a katau. Ka tau mai aku mihi ki rungi a koutou I tēnei wā, a koutou ngā me mō pāremata, a me tēnei mahi nunui I mui te aroaro. Harei te mea ki au kumea tēnei mea ko te mihi e nari ka tangi kau atu mo e rā ahuatanga o ma te rungi a tātou I tēnei wā. Koutou ki te pō, e moi, e oki. Thank you very much for the time, and I'm very humbled to be included amongst some amazing and outstanding speakers this morning. My submission is in opposition to the bill. The proposed bill is one of many in a broader campaign of lawfare, a calculated effort to dismantle Indigenous rights and undermine the constitutional role of Te Tiriti o Waitangi. It represents not just an attack on Māori, but a fundamental threat to our democratic fabric of Aotearoa. The bill attempts to replace a legal pluralism that already exists, one that recognises kawe and tikanga as foundational to our system, with a narrower, exclusionary model designed to centralise power and facilitate resource extraction. It achieves this by freezing treaty interpretations, limiting Māori rights to what the Crown has agreed to through its own settlement process, and reinforcing a legal fiction that full Crown sovereignty was established in 1840. The bill states that its enactment will be subject to referendum. However, constitutional and Indigenous rights should never be put to a simple majority vote, especially when the affected party are a minority within the electorate. This is not democracy. It is a tool for overriding Indigenous rights under the guise of public consultation. The bill states that the Crown recognises the rights that Hapu and iwi had when they signed Te Tiriti. The Crown will respect and protect those rights. Those rights differ from the rights everyone has a reasonable expectation to enjoy only when they are specified in treaty settlements. This statement is deeply misleading. The treaty settlement process was never designed to define Hapu rights. Those rights already existed when Te Tiriti was signed. The settlement process is merely a Crown-controlled redress mechanism designed to address the Crown's past breaches of those rights. By implying that Hapu and iwi rights only exist when the Crown confirms them in a settlement, this bill falsely repositions Māori as subjects of Crown generosity rather than signatories to a foundational agreement. The bill states that Parliament introduced the concepts of Te Tiriti principles into legislation in 1975, partially to reconcile the differences between the two texts. Parliament, however, did not define those principles. Instead of using this fact to uphold the rule of contra preferendum, that any ambiguity in the treaty should be resolved in favour of the Māori text, this bill does the opposite. It moves to define treaty principles in a way that permanently benefits the Crown while stripping Māori of their ability to challenge that definition through the courts. This is not just an overreach. It is a legal manoeuvre designed to lock Māori into a weaker position, stripping away the evolving recognition of kawa and tikanga as a source of law in Aotearoa. The bill states that the executive government of New Zealand has full power to govern and the Parliament of New Zealand has full power to make its laws. This is a deliberate misinterpretation of history. Te Tiriti o Waitangi did not cede absolute sovereignty to the Crown. Instead, it established a partnership where Māori retained tino rangatiratanga over their affairs while the Crown governed in a manner that respected this autonomy. This bill attempts to rewrite the Agreement of 1840 into a document that grants the Crown unilateral power, an outright breach of the treaty itself. In closing, the committee faces a choice. It can align itself with a manufactured, divisive ideology designed to weaken rights and consolidate power in the hands of a few, or it can stand for true democracy, one that recognises the foundational role of Te Tiriti o Waitangi and the pluralistic legal systems that exist within Aotearoa. The bill is driven by fear of what an inclusive, participatory, and truly democratic system could look like. Te Tiriti o Waitangi does not weaken our democracy. It is the foundation of a stronger and more adaptable and more just society. Aotearoa has a chance to lead the world in transforming democracy, not by privatizing it, not by weakening it or using it as a tool for exclusion, but harnessing its strengths for our indigenous systems alongside existing Western systems. This is not something to be feared or deliberately distorted for political gain. It is a future we should be striving for together. E numia te tāwai no tā whitorangi, ko tūpua kawa ko tā whito kawa ko te mātoi o te rangi, tēnā ko te katoa.
Thank you for that. A good submission. And we've got your written submission. One of the terms you use is in terms of if there's any discussion to be had about the principles of the treaty, is it should be had by the Hapu of Aotearoa. What do you mean by that?
I think that you almost said exactly what I mean by it. This is a conversation that we should take it back to Hapu and have that conversation there as a starting point, because they were the signatories of Te Tiriti o Waitangi.
Kia ora. Scott Willis has a question.
Thank you, Hayden. And I'm really just building off Duncan's question, because I see your recommendation is that we reject this divisive legislation, and I agree. And I think what you've talked about is helping to repair the damage. Does that mean we go back to Hapu? How can we repair the damage that this bill has already done?
Yeah, I think having courageous conversations is one step, Scott. Absolutely. I think getting rid of this government is a second step, or at least a coalition, and trying to find real leadership for our country and having real conversations safely so that we can actually move forward rather than divide and separate, which this government has unfortunately led out.
Thank you for that. There being no further questions, I think that brings the submission to a close. But thank you very much for your submission and your written submission as well, Hayden. Very informative.
Kia ora tātou.
Members, our next submitter is Mihiarangi Piripi.
Piripi. Tēnā
Piripi,
koutou.
sorry. My apologies, Mihi. Good to see you, and thank you for your submission, which we have a copy of the written submission here. We've got you for 10 minutes, so I'm very happy just to hand straight over to you to take full advantage of it. Kia ora.
Ka pai. O tēnā koutou katoa, ko Mihiarangi Piripi tōku ingoa, ko te rāroa ko ngā pohi oku iwi. My name is Mihiarangi Piripi, and I am a director at the law firm Fire Legal. I am the descendant of Te Morenga, who signed he hakaputunga as a rāroa, but did not sign Te Tiriti o Waitangi. I also have Pākehā whakapapa, but none of my Pākehā tūpuna signed Te Tiriti o Waitangi. Rather, they later immigrated to Aotearoa. My connection to he hakaputunga and Te Tiriti o Waitangi is deeply rooted in my whakapapa. I was also very fortunate to have an upbringing immersed in Te Tiriti o Waitangi. My parents were part of Te Kawariki, a political movement in the 80s. We grew up in a world where the norm was to challenge the status quo, push political boundaries. We were encouraged to think critically with a strong emphasis on social justice and for standing up for what you believe in, no matter the consequences. I pay homage to those from Te Kawariki, particularly those who are no longer with us, and in particular, the late Jan and Apai Dobson. Today, I provide an oral submission on the submission I made in a personal capacity in relation to the principles of the Treaty of Waitangi Bill. I am conscious of time and the number of submitters and would like to elaborate on 3 points made in my oral submission before leaving time for pārtai. The first point is in relation to Principle 3 of the bill. In my written submission, I said that the bill promotes divisiveness. I say that because Principle 3, as provided for in the bill, states that everyone is equal before the law, and everyone is entitled without discrimination to the equal protection and equal benefit of the law. Further, it provides for equal enjoyment of the same fundamental human rights. I say that the bill creates divisiveness as many people in Aotearoa do not understand Te Tiriti and the ongoing implications of Te Tiriti in lawmaking and in policy making in Aotearoa. Te Tiriti is not actually difficult to comprehend. It is an agreement that allowed for Pākehā to settle in Aotearoa on a range of conditions. Those conditions have been breached. It provides Maori with a set of rights. Maori have not been afforded those rights. Colonisation has ensued, and all of this is not disputed. It is because of this that the Crown has over time attempted to remediate its wrongdoing. Remediation has occurred in many forms, such as Treaty of Waitangi settlements, in the form of lawmaking, and in the legal recognition of what has become the principles of the Treaty of Waitangi. It is important to note that the efforts to remediate have not been accepted by Māori as being sufficient. Many consider the principles of the Treaty of Waitangi to be a diluted form of what the treaty and Te Tiriti actually say. Further, many iwi have not actually settled, including my own iwi of Ngāpuhi. What the bill does, however, it suggests that remediation is not required. It states that the law, being any enactment, but only if the Treaty of Waitangi are relevant to interpreting that enactment, should treat everybody equally. That somehow the passage of time, which is actually rather short in comparison to other jurisdictions, wipes the slate clean. I say the bill creates divisiveness because all one sees is the very tip of the iceberg. All one sees is the person that might miss out on a university spot because of a Māori admissions program. And that person says, why should Māori be treated differently just because they are Māori? As a Māori, I'm not saying that I am better than anyone else on a human level. What I am saying is that systems within Aotearoa must account for remediation based on a breach of rights. This will look different in different contexts. And as Dr. Moana Jackson once said, it seems to me to be quite wrong to therefore call the addressing of need based on a breach of rights as a special privilege. The bill is also divisive as it ignites public debate without going hand in hand with education. In my view, the key to cohesion moving forward is a genuine and respectful national conversation, and that is also embracing it all, the good, the bad, and the ugly. The second point I wish to make is in relation to Crown Māori relations. I am privileged in the work I do that I get to see firsthand the Crown Māori relationship in action, whether this be in the form of partnering, contracting, or at times challenging. The relationship is a delicate dance and is dependent on so many factors, including the relevant law, the nature of the engagement, and how the relationship is engaged. There are ebbs and flows, but what I can say is that in my experience, there has gradually been an improvement. This bill rewinds that progress. Trust has been lost. Some say the bill has caused irreversible damage. The bill is part of a barrage of reform that one can only interpret as an attack on Māori. The all-important Crown Māori relationship has been used for political point scoring. And the very fact that we are here today to discuss a bill that political leaders have said will not be enacted is nonsensical. I urge the government to try and salvage those relationships, as mending them in a meaningful way will be a significant job. The third and final point I wish to make is in relation to the use of a referendum. The bill provides for it to be put to electors in a referendum and for the bill to commence if there are a majority of electors who support the bill. While referendums are not new in Aotearoa, a referendum on this particular issue would be deeply unfair and an abusive process. An agreement cannot be amended without the consent of the parties. Te tiriti is an agreement. Any changes to te tiriti would need to be consented independently by both parties, being the Crown and Māori. However, a referendum process marginalises the voice of Māori. The bill does say that it does not amend te tiriti, but I question how can that possibly be if the practical implementation of te tiriti departs so significantly from what te tiriti actually says. What we have seen and what we should learn from is how minority Indigenous voices fare in a referendum. In 2023, there was the Australian Indigenous Voice referendum that demonstrated this so clearly for us. The Central Land Council, one of the 4 land councils in the Northern Territory, said the referendum result showed Australia was a country that does not know itself. In my view, we need to heed that advice and engage in a genuine and meaningful conversation where the ordinary person in Aotearoa is able to participate fully in that kōrero. That brings an end to my oral kōrero, but I'm more than happy to take pātai.
Kia ora, and we do have some time. And if no one else has any questions, I noted in your submission you allude to the work you did in Australia, where, of course, they've got no underlying treaty relationship or treaty principles. And you worked, I understand, for Indigenous peoples there in the mining space. The absence of a treaty or treaty principles, how did that affect the relationship?
Hugely. So the basis of the relationship in Australia between mining companies and traditional owners is based on what minerals you have that they wish to mine. And so you don't have the government dynamic, rather you have a very commercial mining proponent and traditional owner. Now, that is moving in some respects, and so in WA, there was a move to a Noongar settlement, and in Victoria there is talk of a treaty. So some of those things are changing, but essentially if you are a traditional owner group without minerals present, you don't get compensation in any form.
Good, thanks for that.
Very different relationship.
Yeah. Scott, we've got a little bit of time for you if you're quick.
Okay. Thank you, Mihiarangi. I really appreciate it. And you talked about knowing ourselves, or in the Australian example, knowing ourselves, and to overcome ignorance and divisiveness. And I'm interested in what a respectful national conversation might be, because this certainly doesn't feel like it so far.
Yes, I agree. And I think that it is a slow and steady conversation. It is one that involves Māori from the outset, because I still think even if you have a national conversation where we do get to know ourselves, it is still not a referendum where every single person gets a vote. You still have to have the consent of both Māori and the Crown separately. But in my experience, any Pākehā person who embraces te ao Māori in this country is better for it. And so I don't think it's something we need to fear. I think it's actually something that is beautiful about Aotearoa, and something that is a slow and steady conversation. It's one that involves Māori, and it's about education.
Kia ora. Thank you very much for that. A great submission. Thanks for that. And you can see the time is up. So thanks again, and thanks for that submission. Kia ora.
Tēnā koutou.
Members, I understand we've got Christopher Diack next, who isn't the next submitter on your agenda, but is available at the moment. So we're going to go to Christopher Diack.
Yes, good morning.
Kia ora, Christopher. We've got your submission in front of us, and we've got you for 5 minutes. So I'll hand straight over to you.
Right, I'll be very brief. I support the bill with amendment. Essentially, the bill proposes a reform of the common law, and it's principally directed towards how the partnership principle of the Treaty of Waitangi is developing. I believe that this area of the law does need attention of the House of Representatives, particularly in the light of the QCs claiming that Parliament lacks the capacity to legislate in this manner as proposed by the bill. My essential proposal to you is that a statement from the House of Representatives or Parliament, if it becomes law, should be closer to the historical Treaty of Waitangi, its texts and context. So in that light, looking at the bill at the moment as it stands, Principle 1, as drafted in the bill, is a bit problematic. It's essentially addressed to the supremacy of Parliament issue, which is arisen in context of the partnership principle. However, it seeks to fetter that by 2 clauses that say that you can only legislate in the best interests of everyone and in accordance with the maintenance of the rule of law in a free and democratic society. Both of those issues are matters of judgment. No judge is better placed to decide what those things are than parliamentarians are. And of course, the rule of law, my suggestion would be, if you proceed with that, a fetter on Parliament using the rule of law, that you define very carefully what you mean by that. It's a TARDIS of a concept. Lawyers differ significantly on what it contains, and so it would be an invitation to judges to write large. My second issue is with the Principle 2 and drafted with the bill. The treaty settlements don't really address what rights Maori had in 1840. They're essentially contemporary problems, or contemporary solutions to the problems of unlawful deprivation of property. So my view would be that Parliament is better, or the House of Representatives is better, to focus on a positive statement about what Article 2 actually meant. And we know that we have some idea of what that was. Both Kawangatanga and Tino Rangatira-tanga are missionary Maori terms invented by Henry Williams. He chose those 2 terms. He said, interviewed about around the time, that it meant independence. Necessarily, that means independence under law. So Maori have the right to manage the affairs of their extended kin groups and groups of extended kin groups, and the property thereof. And I think Parliament should actually say that. The key point is that is under law. And the final thing, I'm pretty relaxed about the Article 3 in the bill, except it should simply expressly say that Maori enjoy those rights. So that's really the guts of what I have to say.
Right. Any questions from members? There's no other members that have a question. I'll just ask you this. The treaty principles have kind of been a sort of guide developed by the courts about how to interpret a constitutional and historic document. What's wrong with leaving that job to the courts rather than essentially rewriting it by parliamentary edict?
Well, the treaty principles, as a matter of law, are an invention of Parliament, not the treaty itself. And they represent, in each iteration, they represent the politics and values of each time. So in 72, when the Act was introduced, it was primarily response to Ruth Ross's very influential article in the New Zealand Journal of History. Obviously, the insertion of the reference to treaty principles in the SOE Act, Section 9, again, is about a contemporary statement of what's going on in those cases. So there is a dynamic relationship between the courts and Parliament. You will be aware that Parliament on occasion reforms the law in relation to contract and all other matters, and that's sometimes as a response to developments in the common law. The key thing I'd say is Ivor Richardson wrote about the partnership principle and the original SOE Act, and he noted that 4 months later, essentially the Court of Appeal tried to roll it back a bit and say, well, look, partnership doesn't mean social revolution. It only applies to Crown property and not in every case, and doesn't presume to be equal sharing or anything like that. So I think it's a principle that's got a life of its own, and it needs to be reformed. And the best place to reform that is in the democratic part of Parliament.
All right. Okay. Well, look, we're at the bit over the 5 minutes. So that's
thank you very much.
Thanks for your submission, and we've got your written submission. So kia ora, thanks for that.
Thank you very much. Bye bye.
Bye bye. There was due to some cancellations, we've got a short break. I'm available for a short break, I think. So if we could have you just switch your cameras off, and we will resume very promptly. Please be on a little bit before 10:15. Kia ora. Kia ora, Scott. Other members, if you're online, do switch your cameras on. It's almost past. And if we've got New Zealand Law Society there, we've just taken the opportunity to stretch our legs because we're ahead of schedule, but we're back on track. And hopefully we've got the New Zealand Law Society there in the room. I think we're expecting Rachael Jones and Nick Whittington.
Indeed.
Kia ora, Nick. Good to see you. Is it just you we've got today?
No, Rachael Jones is joining me. I can see her there on the screen, although it looks like she's muted and video's off. Here she comes in now.
Okay, that's great.
Well, tēnā koutou, and if, I can start?
You can start.
Fantastic, thank you. Tēnā koutou, ko Nick Whittington aho, kei kone maua ko Rachael Jones, mō te Kahui Ture o Aotearoa, the New Zealand Law Society. We are representing the Law Society today to present its submission on the principles of the Treaty of Waitangi Bill. We're going to focus on two aspects of the written submission. I'm first going to focus on the flawed process that the bill has followed, and then Rachael will focus on the fact that the bill won't actually achieve its stated objective of providing certainty about the principles of the treaty, and we're hoping to provide enough room for questions within our allotted time. If enacted, the bill will effect significant constitutional change by rewriting the treaty in a way that is inconsistent with its spirit and its two texts. Such significant constitutional reform should be the subject of a robust policy and legislative development process, which is proportionate to the impact that the bill could have on the constitutional, legal, and social fabric of New Zealand. And when you're trying to make such significant constitutional change, it's fundamental that you follow a good process. That process has to be proportionate to the significance of the change, but the process of development for this bill was woefully inadequate. First, there was no prior consultation or meaningful engagement with Maori, the Crown's treaty partners. The treaty is an exchange of promises between sovereign peoples with rights and obligations for each party, so its principles are necessarily matters of international law and contract interpretation. But the Crown's partner was not appropriately consulted at the commencement of that process. Following on from that, and secondly, given that the principles of the treaty are a matter of international law and not public opinion, the process should have included meaningful engagement with experts and pukenga to inform the policy development. It's telling that didn't happen, but it's telling that the chief legal institutions of this country have all submitted against the bill, the New Zealand Bar Association, Te Hungaroa Māori, and extraordinarily 50 Kings Council, who co-signed a submission against the bill, and we support the comments that have been made in those submissions as well as obviously our own. Third, by excluding meaningful consultation and asking the public to determine treaty matters through a referendum, the Crown risks imposing the will of a non-Maori majority onto its minority treaty partners. And finally, on this point, while the select committee process allows an opportunity for public input, it can't realistically inform the actual design of the legislation and its underlying policies, or allow consideration of the various options available to address the policy problem, if there is one, or to meet the policy objectives that have been stated for this bill. So drawing all of those points together, the proposal really to unilaterally impose newly created treaty principles which bear no resemblance to the articles of the treaty is inconsistent with the Crown's legal obligations to its treaty partner. And with that, I'll pass over to Rachael.
Tēnā tātou I te kōwiti o te whare paremata, he uri tēnei no Ngāti Kahungunu, Ngāti Rā Kaipaka Ahau. As Nick said, I'm Rachael Jones and I am beaming in from outside courtroom 13 in Christchurch, where I'm representing Ngāi Tahu currently defending, among other things, the treaty principles. So I'm very pleased to be here today. As Nick mentioned, I will be talking about the principles themselves, or the bill itself, and the ways, many ways in which we, as the New Zealand Law Society, consider the bill will not provide more certainty about the treaty principles. The committee has heard that the existing treaty principles have been developed incrementally and over decades of litigation by determined treaty partners on the one hand, and conservative and deliberative courts on the other. The treaty principles have therefore stood the test of time and the actions of successive governments. And that those successive governments fall on either side of Aotearoa adopting the MMP electoral system. As a country, we already have relative comfort about what the treaty principles are and how they operate as between treaty partners. One of the bill's stated objectives is to create greater certainty. At best, we consider the bill is unlikely to do so, and at worst, we say it will likely create uncertainty. We say this for several reasons, which are set out in our written submission. I wish to expand on two of these reasons today. First, the existing principles are already deeply rooted in instruments which shape executive decision-making and Parliament's lawmaking. These are constitutional fetters on policy and lawmaking grounded in Te Tiriti and its principles. These include the Te Arawhiti Guidelines for Engagement for Māori, the Cabinet Manual, the Legislation Guidelines, and Cabinet Office Circular 19(5). This bill will not amend those instruments. So if it is enacted, the bill would be inconsistent with those instruments. The bill does not say what policymakers and lawmakers should do or not do about the treaty. It only seeks to alter the rights of iwi and hapu. Secondly, the bill provides that the only quote-unquote different rights that hapu and iwi who signed the treaty have are those the Crown has agreed to acknowledge in a historical treaty settlement. That outcome would be inconsistent with tikanga Māori and with the rule of law. Treaty settlements and even Te Tiriti itself do not alone or together bestow the full spectrum of rights for iwi and hapu. For example, Te Tiriti confirms, but is not a source of, tino rangatiratanga. Tino rangatiratanga as a fundamental concept of tikanga Māori pre-exists Te Tiriti, and certainly it pre-exists any treaty settlement. It does not depend on those instruments for its recognition as a matter of law. If the bill is intended to have this effect, it does not do so in clear and explicit terms. Instead, the bill echoes what the Court of Appeal prohibited in its 2004 Ngāti and Attorney General decision in relation to customary title, extinguishment via a side wind. This bill, despite its stated objectives of clarity and certainty, is all side wind. These two concerns demonstrate that the bill on its face is inconsistent with the treaty and its principles. A deeper look at the wording of the bill and the processes it has followed to this point in time reveal the bill would upend the incumbent treaty principles in favour of uncertainty and inequality for iwi and hapu. This should concern all New Zealanders. And for these reasons, the Law Society submits that the bill should not proceed. And if we have time, Mr. Whittington mentioned that we may have time to answer some questions.
Well, we've got a few minutes, or a couple of minutes. Any member got a question? Scott Willis.
Thank you, Nick and Rachael. You've given us a very, very comprehensive submission and very impressive, and outlined that there is extensive legal concern with this bill. Do you think we have taken a good approach? I mean, clearly you don't, but why exactly do you think the legal fraternity is so up in arms about this bill?
Well, it's not just about process, but the process is, as we've suggested, deeply flawed. This is fundamentally a constitutional bill. It tries to tinker with the compact between right at the foundation of our country. If you're going to do that, you should do it in an appropriate way. You engage in with a white paper, or consult the country on what are the fundamental principles of New Zealand. You don't seek to pass a bill that simply rewrites what the treaty means without consulting anyone, or at least the key parties, before introducing the bill. So while the select committee process is a fundamental one for Parliament to follow, it can't actually replicate or make up for the failures right at the beginning of this development of the bill.
Thanks, Nick. We're pretty much at time, but I'm going to go to Jamie Arbuckle for a question.
Thank you, Chair. My question was down a similar line. It's I think over a number of submissions we hear there's been established principles, and you said something there around what interested me around the white paper. So do you think if there had been prior engagement, that we could have got to a stage where we could have had maybe more of the principles that have been established in this piece of legislation, and that would have been a better way forward?
Well, I don't know if you want to tackle that, Rachael, but my thought is that if you're going to make a constitutional change, you go about it in a way that's proportionate to the significance of that change. And if we're going to, for example, create a written constitution, which is that this is moving along the lines towards, well, then you go about it in the sort of way that has been written about by someone like Geoffrey Palmer or Andrew Butler in their books about a written constitution for New Zealand. You don't go about it, as Rachael has said, through a sidewind.
My only additional comment, if I may, Chair, would be to just remind the committee that the bill refers to the rights of everyone, but does not appear to appreciate or perhaps deliberately pushes the issue to the side that the treaty is between the Crown and Māori. It is not the treaty between the Crown and everyone. So in terms of consultation, the correct starting point is with your treaty partner, and whether there's a white paper, a green paper, a blue paper that follows that, it shouldn't be predetermined before that very first basic step of treaty partnership is taken.
Kia ora, thank you, Rachael. And can I just thank the New Zealand Law Society for the work it does on select committees. We're always well informed and well served by oral submissions as well. So kia ora. Thank you.
Thank you. That's our pleasure.
Okay. Members, our next submitter, we have for 5 minutes. No, we don't. We have them for 10 minutes. Bonita Bigham.
Kia ora.
Kia ora, Bonita. Good to see you.
Tēnā koe.
We've got you for 10 minutes, so I'll just hand straight over to you so we can make the most of that time.
Tēnā koe te tiamana, tēnā hoki koutou o te komiti. Nei rā te mihi atu tēnei uri o taranaki maunga kia koutou. Kei te mai mai tēnei whenua tāhua o poke kura I te wā o Matatini no reira tēnā koutou. So I'm coming to you live from Pukekura Park, where Te Matatini is now in full swing, and the world is watching Te Ao Māori at its finest, and a bit of irony for me coming home to now be submitting on the Treaty Principles Bill in this environment. So thank you for your time this morning. I appreciate that you would have read my submission. I'm not a technical expert. I don't have the language skills. I don't have the technical knowledge, as I outlined in my submission and has been so eloquently and articulately expressed in the prior submission to you. I just wanted to talk about my lived experience as a wahine Māori, wahine Pākehā, whakapapa Erua with Māori and Pākehā whakapapa, someone who grew up on the ground here in Taranaki and who continues to serve my community, specifically at this moment as an elected member on the Taranaki Regional Council. What this bill has enabled, in my eyes, is the rise and the rejuvenation of discontent, of malcontent, of misinformation, and of separation in a community here in Taranaki that has worked so hard for the last few decades, and especially the last few years, to help one another to come together in a place where we respect each other's views, where we can sit and talk to each other rationally and reasonably about how we move together as a community. And you will all be aware of the extensive work that the former Mayor of New Plymouth, Andrew Judd, did in this space around the Māori wards corridor for local government, to the point now where all of our Taranaki councils have Māori wards. And that took the community with us, so much so that it was a clean sweep when those issues came through our councils here in Taranaki. What we have now seen is, for some strange reason, many people second-guessing, or not even second-guessing, but just showing absolute cognitive dissonance around everything they would have learned, heard, seen and felt during all of those prior discussions, to where we're now having things happen, like in my regional council, where all of a sudden discussing treaty issues has become too political, and putting a submission into Parliament on this bill was too political. So all of a sudden local government became a political body that wasn't able to be submitting to this bill. So really I'm just here to reinforce all the other wonderful speakers, especially our rangatahi coming through, who those in their 20s and 30s who have only ever known progress, who have only ever known increased understanding, who have only ever known growing up in a world which has become far more accepting and acknowledging them in their in our Māori, where it's cool to be Māori, where it's cool to be who you are, and to have so many tangata tiriti supporting us in this space. They're feeling their world absolutely rocked, where they are feeling, from what I understand, what I have been told, they can't quite comprehend. They feel like the whenua has been literally again starting to be pulled out from under them, when something as simple as a government department name has now had to resort back to being English after becoming embedding in communities for so long. So those are kind of, they might be simple things to some people, but they are ground-shaking, earth-shattering things to others. And that's really where I'm at, koto, just in terms of reinforcing all the wonderful speakers who have spoken into the space. Full tautoko to those who have the technical knowledge, the intellectual knowledge, the institutional knowledge of the processes there in Parliament. This is something, again, that we feel is being done to us, not with us, and definitely not by us. So with that, I'll waiho and send you all our mihi from Te Matatini, where the world's best are here strutting their stuff. And Te Ao Māori is here, Te Motu Katoa is here, and we have visitors from all over the world coming to enjoy what is the Māori experience. How ironic would it be if that experience is somewhat dumbed down by things like this bill and what it means for Aotearoa. Kia ora.
Well, kia ora, Bonita, and it'd be appreciated if you didn't rub it in too much, that you're out there celebrating Matatini and we're in our respective offices listening to submissions. But it's great to see the background there. It looks like you're having a great time. We've got a little bit of time for questions if members have any, but it was a great submission. Scott Willis.
Thank you, Bonita. Yeah, and I just have to reiterate, it looks beautiful there. Look, you've talked about such a lovely story about the way in which our rangatahi have come to appreciate the diversity and strength of our shared story and history. I wonder, what do you think? Do you think this is offering an opportunity or is creating damage to the future? And if it's the damage, how are we going to restore confidence that we do have something unique and valuable for our youth, for our future generations?
Kia ora, he pātai pai. I think if there's anything good that's come out of this, it's the mobilisation of our people, it's the kotahitanga of our people, the fronting up of tangata tiriti to speak into this space, whereas they may have been as complacent as perhaps we had become, and that, the world understood, our country understood, and that we were okay. So that is the positive I see coming from this experience. In terms of the negative, it's been interesting. Some of the rangatahi that I've spoken to have been quite distressed, and a couple have broken down in a couple of situations. And it takes me back to when I was a teenager in the early 80s, and when the mountain debate, is it Taranaki or is it Egmont, was raging here in Taranaki, the same thing. And I have had to relay to these rangatahi that what feels like your world might be rocking now is you will live through this, because we all have to live through this to make sure that we're here for whatever the fight is that comes next. So this is cyclic. This is a pretty major part of that cycle. I think to fix it, this bill obviously has to get dropped. There has to be absolute positive engagement and genuine engagement with Ngā iwi o Te Motu, with the Iwi Leaders Forum, with the Kingitanga, and all of those who are speaking and leading into this space. The rangatahi have to be involved, because they have, as we have seen, they are taking this to the forefront, and they are making all us old ones sit back where we need to be and look at them proudly. So I think if there's work to be done, it's engaging genuinely in those spaces, allowing the rangatahi voice to come through, because we're just here as placeholders for them. They're the ones who are going to take this country into the future. But yeah, he mihi noi ki ngā tangata tiriti kua tū mai te tautoko i a mātou. So huge mihi to all tangata tiriti who have stood in this space, shoulder to shoulder with us on this kaupapa. Kia ora, great question.
Kia ora. Bonita, we're going to leave it there. Thanks very much for your submission, and be a very, very interesting and powerful oral submission as well. So kia ora, ka kite.
Tēnā koe, ngā mihi, ka kite.
Okay, members, the next submitter is the New Zealand Society of Translators and Interpreters. And we should have Ture Ormsby and Augusta Marianacci.
Kia ora.
Augustina. Kia ora, Augustina. And I see we've got Ture coming on now. You'd probably be aware that we've got 10 minutes set aside for you to submit. So I'm just going to hand straight over to you. And if you leave some time at the end, we may have time for questions.
Great, thank you. Tēnā koutou, tēnā tātou katoa. My name is Augustina Marianacci. My tipuna are Italian, and I migrated to Aotearoa from Argentina in 2014.
Tēnā koutou e te kōmeti. Ko Turei Ormsby tōku ingoa. My name is Turei Ormsby. No Ngāti Porou, Ngāti Kahununu me tūhoi. I come before you today as a professional translator and interpreter, and as a dedicated member of the New Zealand Society of Translators and Interpreters.
Today we are representing Te Ropu Kai Whakamaori a Waka-a-Tuhi, also known as the New Zealand Society of Translators and Interpreters, which is the national professional association for translators and interpreters in this country. The goal of the association is to uphold the highest standards of translation and interpretation in Aotearoa, which is why we oppose this bill. I am not here as an expert in Te Reo Māori. Many of my Māori colleagues have and will continue to speak to that matter. Experts such as Piripi Walker, Ian Cormack, Menali Nelson, or my colleague Ture, who is presenting the submission with me, can offer a detailed analysis of the translation flaws in this bill. However, we consider it essential to express our full support for the concerns raised by Te Reo Māori experts regarding the quality of the translations that form the basis of the Treaty Principles Bill. So today I address you as this association's Vice President, as a professional English, Spanish translator and community interpreter, and as a South American migrant. Like me, the majority of our members are Tauiwi, who have come from all over the world with their own language, culture, knowledge, and beliefs to live here in Aotearoa, thanks to the opportunity afforded to us by Te Tiriti o Waitangi.
I think we can agree that the tiriti is an agreement that upholds the belief that people can coexist on common ground, mutually benefiting and enriching each other. But as translators and interpreters, our job is to facilitate communication in spite of difference, so that coexistence can be possible. We believe that everyone deserves to be heard and that language should not be an impediment when it comes to accessing information and engaging with others. And we also believe that the best way to guarantee the quality of that communication is through professional language services provided by qualified translators and qualified interpreters.
As an organization, we understand the weight that language carries. A mistranslation is not just an error on a page. It has very real consequences. So we believe the translations forming the basis of this bill are flawed. And any attempt to rewrite treaty principles using inaccurate translations risks distorting the intent of the original document. As a result, this bill undermines our profession, the original voices of Te Tiriti o Waitangi, and the contemporary voices speaking out against this process. The translation and interpreting professions are not only grounded in language proficiency, but also in trust. When individuals lack the means to verify whether their message is being accurately conveyed, they are forced to depend on us to communicate on their behalf. And this responsibility is immense, which is why organizations such as the New Zealand Society of Translators and Interpreters and the Sign Language Interpreters Association of New Zealand exist. We adhere to a code of ethics that upholds key principles such as confidentiality, accuracy, and competence. We grant membership through a very rigorous process that verifies qualifications and experience. And through these standards, we seek to provide assurance so that those who engage our highly specialized services can trust us, have confidence in our professionalism, and express themselves freely through our work.
Māori have raised concerns about the decontextualized phrases extracted from Te Tiriti o Waitangi and translated from Te Reo Māori into English. We don't trust the translations of those phrases, and that is eroding the relationship between Māori and the Crown. And because we believe in the significance of Te Tiriti o Waitangi to this nation, because we're aware of the power of language and the critical role of our own profession, we urge the government to engage culturally appropriate and professionally qualified translators when developing policies that affect the interpretation of Te Tiriti o Waitangi, the Treaty of Waitangi.
We call on the government to reject the Treaty Principles Bill, as the translations of Te Tiriti o Waitangi fail to meet professional quality standards. Instead, we urge the government to establish and maintain an appropriate framework for engaging qualified Māori translators in all treaty-related legislative work to safeguard cultural and linguistic integrity. By doing so, we can uphold the integrity of Te Tiriti o Waitangi with the respect that this foundational document and all those who live on these lands because of it rightfully deserve. Thank you.
Kia ora. We have time for questions. I have one, but Scott got his hand up first, so I'll go to him.
Hola, Augustina. Kia ora.
Hola.
Ture. Thank you so much, and it's a really interesting submission. Are you surprised that such a flawed piece of legislation, flawed in translation, flawed in process, flawed in law, has made it so far?
I would love to say that I am surprised, but I think that there's a lot of room for improvement in terms of translation and interpreting policy and making sure that professionals are contacted and when for everyone, for any person who needs interpreting. The fact that we work with migrant communities tends to mean that often professional services are disregarded or are not, not prioritized when there are funding issues or when there are other priorities. But I think this highlights the problems that we already have in the industry, not only in terms of Maori translators and interpreters, but also with all other languages and cultures that are living in this country.
Thank you. So my question is about the appropriate approach to translating a document like the treaty, and what the relevance and how you do your job, taking into account kind of the historical context, the linguistic context, and also the current kind of social and cultural context in which the document now sits. Can you comment on kind of the complexity of that job?
I think maybe Ture, would you like to answer this question?
I think foremost, understanding that the treaty was written by Forum is pertinent in understanding the process by which the tiriti should therefore be translated. If we are to leave the translation of Te Tiriti o Waitangi to a single translator, then what you'll find is that the translation is based not only on the skill and aptitude of the translator, but also upon their personal views and their personal reservations. And so where Te Tiriti was written by Forum, I would imagine that Te Tiriti should be translated by Forum in ensuring that there is a group of minds to check each other, to ensure that the thinking is on the pathway that the conventions require. That we're not moving too far out of the box of what is reasonable for a translation. And so there I see some I suppose a pertinent process for or pertinent approach for translating Te Tiriti o Waitangi. And I do not imagine that it's a simple task. As language evolves, whether in English or Te Reo Māori, so do the concepts that are attached to them. For instance, the word coincidence. The word suggests, as we use it today, that the two things that we talk about are completely irrelevant. But the word itself, to coincide, suggests that they are very relevant. And so there you see, with the evolution of language, the concepts that are attached to specific words change. And we need to be really mindful about the history of language when we approach translating language in a contemporary context.
Good. Probably asked you a question that you could do a course on. But we'll have to leave it there because we are out of time. But kia ora, thank you very much for your written submission, but also for your oral submission. Very informative indeed. Kia ora.
Thank you.
Members, our next submitter is Professor Nicola Wheen from the University of Otago. I understand that she is available.
Oh, okay, that better?
You're getting there. I can hear you, Professor Nicola Wheen, but I can't yet see you. But
okay. I'm here. I'm not quite sure what to do about that.
Well, that's okay. It's we've got the main thing.
Here we go. Everything's got cross it. Oh no, on again.
Yes,
there we go.
Kia ora, Nicola. Good to see you.
Kia ora, Duncan. Nice to see you too. Yeah.
We've set aside 10 minutes to hear from you, including questions. So I'm just going to hand straight over to you so we can crack on into it.
Okay. Tēnā tātou, ko Nicola Wheen ahau. I'm a professor of law at Otago Whakaiku Waka, the University of Otago, where I've been teaching public law and teaching and researching the law relating to treaty principles, environmental law for around 35 years. I am a Pākehā of English, Scottish, Irish descent. I want to thank the committee and the chair for the time and attention that they've given to this task. In my submission, I oppose the bill on 3 fronts: that it's undemocratic, unconstitutional, and dishonourable. And I've got a couple of comments to add into what I wrote in my written submission as well. So what I've done today is I've organised my comments in series. I'm still moving through those main points, but I've actually got sort of 5 general comments that I'd like to make. So first of all, the bill proposes to redefine the principles of Te Tiriti and the treaty, and to come into force following a vote of a simple majority in favour at a national referendum of electors. It's my submission that this process is so misconceived and ignorant of the nature and place of Te Tiriti in our constitutional and our governance system, that if it were to be enacted and brought into force, that would challenge the very constitutional foundation of this country. Borrowing the Court of Appeal's language from the New Zealand Māori Council 1987 case, Te Tiriti was and is a solemn compact that allowed for the settlement of this country. It was made between the Crown and Māori. Non-Māori New Zealanders are not party to this compact, and so it's not their role to determine its meaning. Te Tiriti is the basis for the Crown's claim to sovereignty, and undermining it undermines the legitimacy of that claim. My second point, true democracy includes protection of minority rights from the whim of the majority. Real democracy is much deeper than 51% wins anything. Protecting minority rights is not something that unfortunately, that we do all that well here in New Zealand, but we rely very much on the three arms of government understanding and respecting their constitutionally proper roles and providing checks and balances on each other. The fact that judges aren't elected here is an important part of these checks and balances, as is judicial independence, and it's protected in the Constitution Act. The bill seeks to subvert the role of the courts in determining the meaning of statutes, which is principally, of course, where treaty principles sections have been put, and constitutional documents such as Te Tiriti. My third argument or point, submission, the process behind the bill doesn't conform to the processes that various governments, red, blue, multicoloured, have agreed to and adhered to over time. These processes are set out in the guidelines of the LDAC, the Legislation Design Advisory Committee, and Te Arawhiti, and they are set out in the Cabinet Manual. These processes involve considering the impact of legislative proposals on treaty principles, and that's not a void statement because the treaty principles have meaning. So we are to consider the impact of legislative proposals, for example, on the idea of a partnership. And those processes also involve consultation with Māori, who is, of course, the Crown's treaty partner. The processes are based on the substance of those principles and have become part of the legitimate and agreed way of making law here. I repeat that this has occurred over time in a non-partisan and informed way. The development of this bill has flouted these processes and ignores the fact that they're derived from the substantive meaning of the principles. And here I'd just like to recall the comments of Sir Geoffrey Palmer and the submission of the 50 KCs on this point. My fourth point, as you know, the phrase the principles of the treaty has been used in legislation since 1975 and is a key component of almost all legislation enacted in the environmental and social spheres since 1986. When government first chose to refer to treaty principles in legislation, it did so for political reasons and in order to avoid the principles being defined, or allow the principles, to be defined in a non-partisan way by those with the necessary resources, open and accountable and contestable processes, evidence-based methodologies, and decision-making expertise. And I'd just like to recall the previous submission and the comments of the previous submitter on what an appropriate way of identifying principles would be. So the government's response was to first create the tribunal specifically for this task, and then it asked the courts to exercise their totally proper constitutional function of interpreting the principles, treaty principles clauses in acts. They provide those non-partisan, open and accountable processes, evidence-based methodologies and decision-making expertise. In the 40 years since, the courts and the tribunal have derived a set of broad, well understood and flexible principles from the texts of the treaty and Te Tiriti. And the application of these principles in public decision-making has not only benefited Māori. For example, there have certainly been environmental benefits from including treaty principles in environmental legislation. And I can give you some examples if you like, but I'll just move on because it's 10:53. The principles as defined by the courts and the tribunal are, if anything, a moderated compromise between the treaty and Te Tiriti. These principles are now embedded in our law and constitutional practice. To redefine them using processes that are not reasoned or evidence-based and are wholly partisan, undermines the current constitutional and legal position and meaning of treaty principles. Finally, in my submission, I argued that the overriding objective of the bill, as stated in its explanatory note, is misleading, and that the proposed definition of treaty principles is apparently deliberately ignorant of the purpose and text of both the treaty and Te Tiriti. To promote such a bill is inconsistent, I argue, with the honour of the Crown and slurries the international reputation of Parliament and government in Aotearoa, New Zealand. In terms of misleading objectives, the bill's explanatory notes is about providing greater certainty and clarity and providing an opportunity for a national conversation, a more robust, widely understood conception, and all these sorts of things that are said in the explanatory note. However, there is an abundance of certainty and clarity about the meaning of the treaty principles in legislation. There are hundreds of court cases, and there is plenty of commentary where Parliament has deemed it necessary. Greater clarity has been provided by the use of elaborated principles sections, for example, Section 12 of the Exclusive Economic Zone and Continental Shelf Environmental Effects Act 2012. We've had lots of conversations about the treaty and its place by Matiki Mai, Sir Geoffrey Palmer and Andrew Butler, and those methodologies are not divisive and haven't been based on a selective reading of the treaty. I find it very difficult to see how this is going about building consensus. Most significantly, Article 2 guarantees rights that, in the treaty, guarantees rights that are exclusively Māori, and expressly says that Māori are entitled to the unqualified exercise of these rights. Whereas the bill purports to unilaterally limit Article 2 rights to historic rights formerly claimed by Māori before 1992 and subject to the settlement process or in settled claims. So it's 10:55, so I'll stop.
Thanks, Professor. Now, we've got a little bit of time for questions. If Scott Willis has one, so we'll go to Scott, just quickly.
Thank you, Nicola, from a wet Otapoti. I really appreciate it. What's the, I think what you've outlined with the undemocratic, unconstitutional, dishonourable, that there is some harm that this treaty principles bill is doing to Maori Crown relationship that's forged by Te Tiriti. What damage do you think it is doing at the moment, and what can we do?
Well, I think it's not only damaging the Crown Māori relationship, and I think that's partly because it's a lack of a trust kind of issue again. You know, we've been going about this for 40 odd years or so, and we've got to a space where we know what we're doing, and we've got basic sort of buy-in to what is going on. And this just is, to me, a deliberate attempt to sort of upend that. We've seen the division that it's caused, and it's not just affecting the Crown Māori relationship, but obviously it's affecting the relationship between the Crown and non-Māori New Zealanders and Māori and non-Māori New Zealanders. And I think that's incredibly sad. I'm incredibly disappointed by the whole process.
Thank you, Professor. Thank you for your written submission. I know you're used to speaking for 50 minutes on end. And it must be hard to do 10. But I'm going to have to leave it there.
Thanks,
so thank you very much again. Ka kite.
Kia ora.
Members, our next submitter is Gareth Hughes, who we also have for 10 minutes. Kia ora, Gareth, good to see you. And you know how this works. We've got you for 10 minutes. I'll hand straight over to you so that you use that time best you can.
Oh, thank you, Mr. Chair, and kia ora members. Ngā mihi nui kia koutou kia ora. Whānau mai au e te taha Aotearoa, Tarawhiti, Gisborne, Hiuri Ahau, no Wales, Scotland, kia te noho o kia Poniki, Wellington, ko Gareth Hughes, toko ingoa. I'm Gareth Hughes. I'm the Director of the Wellbeing Economy Alliance Aotearoa. When I say to you kia ora, the literal translation of that is be well, and that's what we're about. And I think and a pan-partisan perspective. So We All Aotearoa is a Te Tiriti-led, non-partisan think and do tank, building a movement, empowering people to redesign Aotearoa's economy around the well-being of our people and te tau. Our vision is a more prosperous Aotearoa as measured by the well-being of our communities, the health of our environment, the inclusiveness of our societies, not just as measured by the quantity of GDP. We believe in an economy that puts our human and planetary needs at the centre of the activities, ensuring these are met equally by design. We're part of a global collaboration with leading new economy thinkers from all around the globe, including governments and academics and policymakers. We're calling for a fairer, more caring, intergenerational, circular, regenerative, connected to nature economy. And what I'd point out is this is nothing new. This is all intrinsic to our Māori. I've come to this mahi after 25 years trying to make a better world, including serving as a decade as a member of parliament, and I see the need for systemic solutions to our unjust and unsustainable economy. And I'd like to bring an economic perspective to the treaty principles submission today, because where I see the leadership, the energy, the innovation, the new thinking in economics in Aotearoa, New Zealand, it's coming from Te Ao Māori. This bill is a massive step backwards after decades of slow but steady progress. This year is the 50th anniversary of our country's efforts towards post-colonisation truth and reconciliation through our Waitangi Tribunal. This has led to a more harmonious nation and genuine Māori economic empowerment. As you'll know, one of the best and most meaningful parts of your job as an elected representative is passing treaty settlement bills. Can I acknowledge the national members on this committee? Your party has an honourable history of a large number of treaty settlements passed, including the world-inspiring Te Urewera Act 2014, the Te Awa Tupua Whanganui River Claims Settlement Act 2017, enshrining legal personhood and co-governance. It's baffling to now see this retrograde bill supported at its first reading. It's such a waste of money, such a waste of time, and such a waste of goodwill that's been built up over 5 decades since the Waitangi Tribunal's establishment. This bill, I believe, is the legislative equivalent of ACT's new school lunches. They're trying to take something that was full of flavour, full of diversity, full of colour, something healthy, successful, benefiting local economies, to something bland, colourless, only benefiting profit-seeking multinationals. What they've tried to do is break something that was working, and like our school lunches, the Treaty Principles Bill is leaving a sour taste in the nation's mouth. I agree wholeheartedly with the Waitangi Tribunal that this bill is the most comprehensive breach of the treaty in recent time. I'm aware there's no expectations this bill will proceed, but I urge the committee and its members to not only oppose this bill, but to condemn it. In the course of only 1 year, 50 years of weaving together a treaty relationship has started to unwind and fray. So much damage has been done to the Māori Crown relationship. This bill is an attempt to arbitrarily, unilaterally, and ideologically rewrite Te Tiriti o Waitangi in practice. As the Waitangi Tribunal points out, Principle 2 breaches the principles of tino rangatiratanga, kawanatanga, partnership, and active protection. This bill excludes other important principles found in tribunal reports, including the principle of exchange, the principle of good faith, the principle of mutual benefit, the principle of reciprocity, the principle of tino rangatiratanga, principle of options, principles of equity, and mana motahaki. For Aotearoa, these principles are crucial for a healthy economy in service to the people and te tau. This disrespectful, divisive bill needs not only to be defeated at its second reading, but to be comprehensively rejected. From this point, there needs to be a project of redress, an apology for the hurt caused, and a commitment that the lessons will be learnt, and the other attacks on Te Tiriti and Māori self-determination, and considerable effort put back into restoring that relationship and partnership. It's not just this bill, though, is it? This bill, it is a cynical diversion and distraction from other laws and bills aimed at creating division and holding back a Te Tiriti-led economy and future. I would urge all members, if they're against this bill, extend that logic, extend that care for social cohesion, and also reject removing Te Tiriti from 28 acts, as is currently proposed. Reject the Māori wards legislation, which has been so comprehensively opposed by our elected local governments, and reject the Marine and Coastal Area Takutai Moana Customary Marine Title Amendment Bill. Referring to economics, property rights are a foundation of how an economy operates, and normally, We would be shocked if the Crown compulsorily confiscated huge areas that had been occupied continuously over hundreds of years and put that into public ownership. I bet right now people would be screaming communism. Yet that's exactly what's happening as the moves to customary marine title held over generations are moving to public ownership. Members, the treaty is a korowai that protects our country. If we collectively want a healthier economy and improved quality of life, it has a foundational role to play. 40 years ago, this year, or last year, New Zealand followed the US examples and put in place a neoliberal operating system, Rogenomics. In the US, they call it Reaganism, in the UK, Thatcherism. Today, we just call it the economy. In our past, treaty principles have proved a significant roadblock to both corporatisation and privatisation and has succeeded in keeping our lands and assets in public ownership. Rupert O'Brien points out the treaty principles, as expressed through the courts in the Waitangi Tribunal, such as the 87 Lands case, kept public land from being privatised. Tribunal claims, such as the radio spectrum, ensured Maori have a fair share of the FM spectrum in place for their language and culture. And it was the treaty that helped keep 51% of our electricity companies' shares in public ownership. The treaty has been a protector of our lands and our waters, with Maori having a leading role stopping seabed mining and offshore oil exploration. In 2021, the Supreme Court in Trans-Tasman Resources versus Taranaki Whanganui Conservation Board rejected TTR's application to mine the seabed and found that a tikanga-based customary rights and interests constituted existing interest when considering any effects in the environment under the EEZ Act. The treaty is a korowai that has protected our people, our lands, moana, and assets. I also believe it can be the foundation of a modern, prosperous economy. Today, 2/3 of New Zealanders believe the economy is rigged to benefit the rich and powerful. Following Reaganism, our two countries, the US and New Zealand, have headed in similar directions: more inequality, more homelessness, more poverty and social division. Instead of being the economy in service to people and planet, right now it's people and planet in service to the economy. But our economy is designed and can be redesigned. And we see so many examples where this is happening today in Aotearoa. You can see it in Te Runanga o Tō Rangatira, where they call it the tō economy, where prosperity is supported by a culture of self-determination, resilience and growth. You can see it in the entrepreneurial sphere with manaho, the Māori theory of value conceptualized by Dr. Jason Meeker, which combines mana, power, authority and dignity, with ho, the vitality of people, places and objects to achieve multi-dimensional well-being. You can see it in the aroha economy, a new economic paradigm developed by Kane Kiruana that integrates indigenous knowledge with modern economic practices designed to be generous, regenerative and generational. We all know New Zealand struggles with long-term thinking, and again, we can see leadership in the Māori economy space with Tai Tauihu, the intergenerational strategy, the long-term economic development strategy on the top of the South Island, led by Whakatu Incorporation with a 500-year plan. You can see it in those reimagining business, such as Hukarangi Enterprises, a charitable company driving economic development and employment in Te Tarawhiti. You can see it in Rua Bioscience, which in 2020 became the first company founded by a Māori community to list on the stock exchange. You can see it in IndigiShare, empowering the indigenous economy through the power of koha, and No Maira, the first kaupapa Māori power company, actually helping their companies. You can see it in Amotai's registry of 1,600 Māori and Pacifica own businesses. We can see the future in this space. So members, I believe we can see a wealthier future, a richer future for all New Zealanders, as one built on Te Tiriti and honouring that partnership and promise made in 1840. Kia ora koutou.
Kia ora, Gareth. Thank you very much for that. You've pretty much taken up your entire 10 minutes, so we haven't really got enough time for questions, but thanks for your submission and the work that you do. And for your written submission as well. Kia ora.
Kia
ora. Members, our next submitter is Te Atiawa o Te Waka-a-Maui Trust. And I think we've got Justin submitting for the trust.
Kia ora.
Kia ora, Justin. Good to see you there. We've got you for 10 minutes. And so in the interest of time, I'm just going to hand straight over to you to make your submission. Kia ora.
O e mihi ana ki a koe i te hia mana me te committee whiriwhiri take Ture. E mihi ana ki a koutou mō tō koutou wā me tō koutou mahi ki te whakarongo ki ngā whakaronui. Ko Justin Carter toko ingoa, ko au te pai whakahaere o te Atiawa o te Waka-a-Maui. I'm Justin Carter, I'm the Chief Executive here at Atiawa o te Waka-a-Maui, and I'd like to spend our time today to focus on a number of key aspects and concerns linked to our submission. Like many other iwi who have submitted on this bill, I want to begin with an extract from the Crown's apology to Te Atiawa o te Waka-a-Maui. From our 2012 deed of settlement and enacted in Ngati Kuata, Ngati Rāroa, Ngati Tamaki, Titawihu and Te Atiawa o te Waka-a-Maui Claims Settlement Act 2014. From section 19, paragraph 5 of the Claims Settlement Act 2014, I quote, "The Crown unreservedly apologises to Te Atiawa o te Waka-a-Maui for failing to honour its obligations under the Treaty of Waitangi." Today, I stand on behalf of Te Atiawa to strongly oppose this bill, that if enacted will undermine the integrity of that apology and our settlement. Section 19, paragraph 5 further states, "Through this apology, the Crown seeks to atone for these wrongs and hopes that this settlement will mark the beginning of a new relationship with Te Atiawa based on the Treaty of Waitangi and its principles." The Te Atiawa settlement followed decades of effort and pain and hurt, but provided a voice to our claims, leading to an apology, redress, and a future commitment meant to be full and final. This commitment isn't token symbolism. It's an agreement to shift from historical failure of the Crown to a future of active collaboration and not repeating the past. The Crown's apology and commitment to a new relationship with Te Atiawa based on the treaty and its principles are not self-contained. They signal an ongoing obligation tied to a broader legal framework with legislation such as the Resource Management Act, Conservation Act, and Local Government Act. This legislative framework upholds the commitments made by the Crown and operationalises the treaty through requirements to have regard for or give effect to principles of the treaty, which ensures our settlement redress is effective. For instance, statutory acknowledgements rely on agencies having regard to treaty principles under the Conservation Act, securing Te Atiawa's input on resource and conservation decisions affecting our rohi. The Crown's pledge to respect the treaty and its principles relies on this legal ecosystem to remain intact, a point this bill threatens by redefining or weakening those principles. An unreserved apology from the Crown means nothing if it is followed by action that undermines the very rights the Crown apology was intended to acknowledge and address. If the Crown's apology to Te Atiawa was sincere, this bill, described by the Prime Minister as divisive and unhelpful, would not have been supported. It would not have been a negotiated concession in coalition agreements. It would not have been the cornerstone of a broader concerted effort to erode legislative treaty safeguards across more than 28 pieces of legislation that in some cases provide the only mechanism in which the Crown is required to uphold and enact its treaty obligations. It would not attempt to deliberately weaken the very mechanisms the Crown agreed to and enacted through our settlement, mechanisms that uphold the very treaty principles that apologise for breaching. Negotiations around the coalition agreement exposed this bill as a political compromise, omitted for being not original policy but a concession to satisfy another party's agenda. For Te Atiawa, this signals a retreat from the Crown's obligations and duties and undermines the trust that we have built and continue to build since our settlement was enacted in 2014. Our settlement wasn't a one-off fix, but it was the foundation for an ongoing relationship. And we're concerned that the government has willingly traded the integrity of our settlement agreement for political gain. And in doing so, is contradicting the Crown's apology as well as its ongoing commitment to Te Atiawa through the enacting of our Settlement Act. This bill cloaks the true purpose in the language of fairness, but its design to us is clear: to dismantle Māori rights and weaken the Crown's treaty obligations. Its promoters push a false narrative, claiming that honouring Te Tiriti somehow clashes with the human rights all New Zealanders are afforded. They distort the Crown's specific duties rooted in partnership and justice as if they were unfair privileges for Māori, masking their intent to unravel protections and justice hard won by iwi like Te Atiawa. The Waitangi Tribunal's December 24 interim report expresses this. It states, the Crown's approach breaches partnership and active protection, prioritising its authority over Māori duties. It adds that the bill misrepresents Te Tiriti, reducing Māori rights and ignoring tino rangatiratanga guarantees. Far from clashing with universal rights, these guarantees, such as Te Atiawa's voice in Aotearoa, are the Crown's legal and moral obligation, not a privilege to be erased. By framing treaty obligations as divisive, this bill's supporters obscure the real aim, stripping away the very principles that ensure justice. This threat compounds the Coalition's review of 28 laws, including the Conservation Act and Crown Minerals Act, where they've signalled plans to remove or amend treaty clauses. For Te Atiawa, this bill weakens the practical effect of our settlement, risking the practical effect of mechanisms like statutory acknowledgements that secure our input on key matters. Without these, the door swings open for exploitation, unchecked by accountability and the treaty obligations that the treaty obligations ensure. The Tribunal warns this breaches the Crown's duty of active protection, a duty anchored in Te Tiriti and reaffirmed in our settlement's hard-won redress. By wrapping this agenda in rhetoric of equality, the bill deceives the public, concealing a calculated strategy to erode the treaty's intent and the justice it demands. Supporters of this bill argue it clarifies treaty principles to promote fairness and unity, safeguarding settlements while delivering equality for all. The reality proves the opposite. Far from protecting what Te Atiawa secured in 2014, it tears at the fabric of our settlement. The Waitangi Tribunal's December 2024 interim report lays bare this. The Crown's approach breaches partnership, a breach that doesn't unite but divides, eroding the rights we fought decades to restore. Legally, this bill stands on shaky ground. It sows uncertainty and invites disputes. The Crown's pledge in 2014 that our settlement was full and final, a commitment meant to close the wounds of history and set our sights forward together. Yet this bill threatens to rip that open again, weakening the legal foundations we rely on to uphold our voice and through our redress. The Crown's apology in 2012, cemented in our settlement, promised a new relationship based on the treaty and its principles. To erode those promises by 2025 is not just a policy shift, but it's a betrayal that strips the Crown of its integrity. This isn't equality, it's a retreat, undoing decades of hard-fought collective progress towards justice for Te Atiawa. Just to conclude, the bill threatens the reconciliation and justice we have fought to reclaim. It undermines our settlement, it hollows out the Crown's 2012 apology, and lays the groundwork to dismantle treaty protections for short-term political gain. It's not fairness, it's calculated retreat from the collaboration we built, striking at the heart of our settlement and Te Tiriti itself. We strongly condemn this bill. We urge the committee to reject it outright. Honour Te Tiriti o Waitangi as it stands, not redefined, not weakened, not traded away. Equity mātou e wareware, ka tū tonu mātou ki te tiaki i ngā mana me ngā tika o Te Atiawa. Tēnā koutou, tēnā koutou, tēnā tātou katoa.
Nā koe, Justin, thank you for that. We've got about a minute left if any members have a question. Scott Willis.
Thank you, Justin. I think you've made some very solid and practical recommendations, and I think we've heard that the Treaty Principles Bill is an attempt to nullify tino rangatiratanga. What are the dangers that you see that we're presented with in this proposal for more free market exploitation of nature in particular and in your rohui?
Well, look, I think as it currently stands, we already have quite a big task trying to uphold our interests and trying to, on behalf of Te Atiawa and the wider community, protect environmental interests and protect the taio. We have a responsibility as kaitiakitanga here where we reside in Titawihu, and through some of what's been proposed, we feel that there will be it will be challenging. It will be more challenging with our relationship with the Crown to ensure that our voice is heard and not ignored as we move forward. We are a partners to the Crown. We offer a lot of support and advice, and we have ways of working that can be really beneficial for the tao environments in our communities. We have a lot of collective agreements through Tiko Taitango Mo Te Taiao Alliance. We have a lot of collaborative things that we do alongside the Crown and local government currently. This bill will erode the foundation that some of those arrangements have been built on, where we are achieving collective action right across our region.
Kia ora. No, Mihi, thanks, Justin. We are out of time now, but thanks for your submission. And of course, we've got your excellent written submission as well. So thank you for that. Kia ora.
Kia
ora. Members, our next submitter is Te Runanganui o Te Atiawa ki Te Upoko o Te Waka-a-Maui Incorporated and Waiwhetu Marae Trust. And I think we've got Kura Moiahu submitting. Kura, I've got you. See, you're online. Can't yet see your video or hear you.
Yep.
There you are. Got you. Kia ora, Kura. You are probably familiar with how this works. We've got you for 10 minutes, including questions. So I'll just hand straight over to you.
E te komiti tēnā koutou. My name's Kura Moiahu, and I am here on behalf of the chairman of Te Runanganui o Te Atiawa ki Te Upoko o Te Waka-a-Maui and Waiwhetu Marae Trust, and present this whole submission from under my ancestral maunga koro Taranaki that was released from its shackles by the very oppressive the Crown earlier this year. I'd like to take my submissions as read. However, I would like to highlight just a few points and add further comments to support the submission, and that the submission is based on our local narrative of Wahika here in Wellington. In summary, we strongly oppose the proposed principle of Treaty of Waitangi Bill, demand its immediate and unconditional withdrawal. The bill fails to demonstrate absolute care in everything that we as Māori do and the well-being of tangata tiriti, which has caused and will continue to damage long and lasting relationships. The bill lacks the courage to address the real issue of facing our nation. It seeks to unilaterally redefine the principles without proper consultation or consent from the other party to te tiriti of Waitangi. True courage is inclusive, involving active engagement in a meaningful and comprehensive manner. The authors of this bill have deliberately refused to initiate a national dialogue with its partner about our constitutional future. The bill fails to recognise the spiritual and cultural significance of te tiriti o Waitangi, severing the intergenerational spiritual connections to our tupuna, undermining the tino rangatiratanga Crown relationship. It prioritises a narrow interpretation of equality that fails to account for the unique status and rights of tangata whenua, which does not serve the needs of Māori. The bill's approach contradicts the principles of working cohesively. It fails to communicate accurate te tiriti o Waitangi principles clearly, and that when viewed through the lens of Te Atiawa, who are ahika to the region in Wellington, it falls short of upholding our kawe and tikanga. As an example, when the motu strongly opposes the Crown's decision and national activations are initiated, like the occupational parliament and the biggest hikua that Aotearoa has ever seen, like that which came to our backyard in November last year, there's no consideration about how we as ahika receive and accommodate the huge numbers, and are often the afterthought about how we receive the motu. Our mana also gets trampled. The bill's approach contradicts the spirit of partnership, care, and mutual understanding that should guide our nation's development and decision-making processes. The bill represents an assault on the foundational relationship between Māori and the Crown, threatening to dismantle the very essence of Aotearoa New Zealand's constitutional framework. The Waitangi Tribunal has unequivocally stated that this bill would constitute the worst, most comprehensive breach of Te Tiriti in modern times if it is to be enacted. And therefore, on behalf of the Runanganui o Te Atiawa and Waiwhetu Marae Trust, we demand that the Select Committee recommend the immediate and unconditional withdrawal of this bill. We actually urge the committee to prioritise evidence-based decision-making and critically examine this bill's motivations, particularly in its potential to exacerbate racial tension and social division. But we also demand that the government engage in meaningful consultation with Māori before proposing legislation affecting Te Tiriti rights and relationships. Te Runanganui o Te Atiawa and categorically rejects this bill and asserts that it represents a deliberate and dangerous attempt to undermine the progress made in Crown Māori relationships over many decades. Therefore, we call on the Select Committee to stand on the right side of history and reject this divisive and harmful legislation. Yesterday, I stood with my people at the pōhiri o te matatini o te Kahui maunga, te Kahui tupua, te Kahui wairua, at Maratahu Huakai, dressed in white and guided by the principles of our Raukura, proudly standing as our tupuna did, passively resisting introduced legislation of last century. And as we stood in unison to welcome the motu, we also stood as a symbol of passive resistance of the current actions of this bill. We stand firm in our commitment to upholding the principles of Te Raukura and the principles of Te Tiriti o Waitangi, protecting the rights and interests of tangata whenua and tangata tiriti. If you want to hear the voice of Te Ao Māori, hara mai ki te matatini o te Kahui maunga, te Kahui tupua, te Kahui wairua. We urge the Select Committee to recognise the grave implications of the bill and reject it outright in the best interest of all New Zealand. In closing, I leave you with this whakatauki pertinent to that of us in Wellington. Te Atiawa tu Porou he au ripo I te manganui e kai tiaki o te ahika ki te whenua. Te Atiawa of many phenomena. For every ripple in our harbour, there is a guardian of those who continue to keep our fires burning on land, which basically literally meaning in closing that there are many governments that come and go in our takiwa, but we as ahika will always remain. Nō reira, tēnei ka mihirawa tura kia koutou e tuku miti, I tēnei āhuatanga o te wā, I taku pānu I te atura ki koutou, nō reira, tēnā koutou katoa.
Ngā mihi, thank you, Kura. We've got a few minutes for questions, so members, if you do have a question, Scott Willis.
Thank you, Kura. We've heard from you and from many submitters that we actually need some respectful national dialogue to overcome the ignorance and divisiveness of this bill. And I'm wondering, do you have any thoughts on what we could do? What would be better? How would we engage in that dialogue in a meaningful way, rather than as this is run through?
Definitely making sure that you have the right advisors by your side to ensure that they're able to connect those relationships, not only with the post-settlement entity groups or settlement entity groups, but with whānau and hapu. Because there is a really, really strong need for whānau and hapu to participate, which they don't get the opportunity to participate in the settlement with the settlement entities. So that's the first thing. And ensuring that making sure that you have communications and those advisors who have those connections, not only just to the iwi chairs forum, but those who have a strong traditional leadership connections as well.
Well, thank you. We've got a question from Takutai Tashkim.
Tēnā koe. Matua, you have prominent role around Parimata and with what you do there on the daily. What message would you leave for your mokopuna?
I think an important message has been left beside by a prominent Māori leader, Sir Runanganui. E te puere ngā rao tā mō tō ringa ki te rāko te Pākehā ko tō ngākau ki te ao Māori. And as Māori, it's a very hard fine line that we have to walk. Place your hand to those things of the Māori, however, those things of your, to the things of the Pākehā. However, those things of your Te Ao Māori world, hold on to deep within your heart. So I'd encourage my future mokopuna that continue to strive in both worlds, but hold on to the most important thing of who we are, and that's our cultural identity, because I believe that if you bring both of those worlds together, that Sir Runanganui had an amazing legacy for us to achieve.
Kia ora, thank you for that. We are out of time, but thank you very much for your submission, and thank you for, as you say, your written submission, which we've read. Thank you very much for that. Members, the next submitter is Peter Saunders, who we have for 10 minutes. Kia ora, Peter. Good to see you there. We've got you for 10 minutes. We've got your written submission in front of us as well. So without further ado, I'll hand straight over to you.
Thank you. Good morning. My name is Peter Saunders. I would firstly like to thank the committee for the opportunity to take this submission. By way of background, I'm a fifth-generation New Zealander, a descendant of farmers and business people, and who have fought in wars, paid their taxes, and contributed positively to the building of this great democracy we call New Zealand. I'm at heart a patriot who believes strongly in the democratic principles of nationhood, one man, one vote, the rule of law, individual property rights, and most importantly, freedom of speech. In my opinion, these are the foundation stones of our democracy. Sorry, I lost it. Personally, I believe the Treaty of Waitangi has been a net positive for New Zealand, including Maori. It initially brought about the immediate cessation of the widespread warfare, enslavement, and members of opposing tribal groups and other undesirable customs, while also providing a relatively peaceful way to build the bureaucratic platform needed to progress toward nationhood. There is no doubt there were treaty breaches by the Crown over the ensuing years. Some of them were significant. However, as a country, we have made an honest attempt to redress these breaches, which in the case of most iwi has enabled them to develop a solid base of financial autonomy. Unfortunately, we are in the unusual position where many laws passed by Parliament now require compliance with the principles of the treaty, despite there being no authoritative list of what those principles are. The courts, the Waitangi Tribunal, and academics now determine what those principles are and which ones should be applied in any particular circumstance. That uncertainty helps no one but lawyers. It does not help us to unite New Zealand. It does not help New Zealand continue to progress and develop as a modern, successful country. The concept of the Crown, while slightly esoteric, is actually quite simple. It is actually all of us. It is every third, fourth, or fifth generation descendant of the early settlers. It is also every recent Chinese, Chilean, Filipino, or Indian immigrant. And importantly, it is all those who identify themselves as Maori, most of whom share significantly more genetic similarity with these settlers and immigrants groups than the tribal chiefs that signed the treaty in the first place. The Crown certainly is not Great Britain, nor is it the British Empire, and hasn't been for well over a century. When the Crown is undermined, when Parliament is undermined, we're all undermined. Our democracy gets weaker, and our ability to work together on other big issues gets harder because the trust between us all is eroding. The vast majority of MPs appear to be running away from what I believe is the most pressing issue facing our country and our democracy. The bill is not about redressing historical grievances or taking away existing rights, as some in the media seem to believe. The bill simply adds certainty to what the principles are. If members of this committee don't agree with the principles listed in the bill, I challenge them to provide the country with their definitive list and how they intend to articulate those principles to the whole population. Continuing to allow activists to decide how they think the law should be interpreted, rather than interpreting what was intended by Parliament, is a dereliction of your duty as MPs. You need to have faith that the citizens of New Zealand are grown up enough to have this conversation and want an outcome that will set the country and its citizens in good stead for the next 200 years as a thriving democracy. Thank you.
Thank you for that, Peter. We've got time for questions. Members, any members have questions? Look, I'll ask you a question then, if I may, and
sure.
It's really around the functions of the courts, which seems to have been a central theme. I'm really curious as to what you consider the relationship between the courts and Parliament to be, because in many developed democracies, the relationship between the two is, reciprocal, in that the courts are in some ways a check on excesses of Parliament, and Parliament, of course, gives direction through laws as to what the courts are to implement. Do you see that as a kind of reciprocal and equal relationship, or something different?
I certainly see that Parliament should set the precedent, or as the premier decision maker, and if it doesn't agree with what the courts have decided, it should have the ability to either change legislation to ensure that the future decisions made by the court are to its expectation. But I also think we're in an interesting constitutional situation where, unlike the United States, we don't have a constitution, which is written and therefore much easier to articulate and to ensure that the legislation or that the way the courts are interpreting it meets the constitutional requirement. I also think that because we've lost the ability of the Privy Council to look over the shoulder of decisions as a final arbiter, we don't get a fully, what's the right word, impartial view of the way the legislation should be looked at or the way it should be interpreted. And therefore, we've kind of lost a trick or lost a final check and balance. And we don't have an upper house. We don't have a lot of the checks and balances during the legislative process that other countries have. So, for example, Australia and Canada, who both run along a similar Westminster system to us, both have upper houses. We don't have that. UK obviously does. And so, we find ourselves slightly lacking and I think slightly at the mercy of the judicial system because of that. Does that answer the question, Duncan?
I think there's some ways. I'm not sure I want to have a upper house of bishops and
I'm not necessarily saying we do that I do either. But what I am saying is that because we don't have one, some of those legislative decision-making processes aren't covered off, and also or aren't looked at from a different perspective as they are by the House of Lords or in other jurisdictions. But also we don't have that slightly impartial or detached view that we used to get from the Privy Council. So we're in a situation where we're missing a wee bit. I think we've lost some of those checks and balances that we had as we set up the democracy in the first place.
All right. Look, thanks. I think we'll leave it there. But thanks for your submission, and I've got your written submission in front of me as well. So thank you also for that.
Thank you for the opportunity. Yes.
Members, our next submitter is Edward Valandra, who. Sorry, let's go back to that. And we have Edward for 5 minutes.
Can you hear me?
I can hear you, Edward. I can't see you yet. If you wanted to be seen, you pop your camera on.
Let's see. I'm not. Hold on. Can you see me now?
Yeah, got you there. Kia ora. Edward, we've got you for 5 minutes, so I will just hand straight over to you to speak to your submission, and if we have any questions, we'll deal with them at the end.
Okay. My name is Wambly Wapaha Hokshila. I am honored to present this testimony on behalf of my Maori relatives and to the settlers of New Zealand. I was born and raised in my homeland, the Oceti Shakaway Makoche, where I currently reside. I am a citizen of the Oceti Shakaway Oyate, and my territory is located in the geographic center of Turtle Island. My people have also signed several treaties with U.S. settlers, the 1851 and 1868 Fort Laramie treaties being the most definitive. Thus, I understand all too well the domestic division and the international alarm that the treaty principle bill is causing. Just like in the United States, where equality before the law is often considered the cure-all for racial issues, the bill's sponsors claim that the treaty principles bill will fix the Maori problem. However, I want to make it clear to New Zealanders that their problem does not rest with the Maori, but with their failure to recognize the permanence and sovereignty of Maori people. Ironically, the treaty principle bill highlights that failure. In the US, there exists a belief among white American settlers that their laws are colorblind, and that regardless of race, gender, sexual orientation, religion, class, and so on, opportunities are boundless. The proponents of the Treaty Principles Bill convey similar sentiments. However, my testimony and perhaps others demonstrate that this belief is not rooted in reality. For Indigenous peoples, people of color, and other marginalized groups in the US, our racial reality is significantly different from those of white settlers, just as I am sure it is for our Maori relatives in New Zealand. For example, on January 6, 2020, we witnessed thousands of insurrectionists, many of whom were overwhelmingly white, storm and wreck the US Capitol. It is telling that a white male president issued them pardons when he recently assumed office. It is well known among non-whites in the US that had the insurrectionists been other than white, the outcome would have been horrific. It raises a glaring question. Why is the rule of law not applied equally? I am sure that if the Treaty Principles Bill is enacted, you too will have the same question, or you will be asking the same question. Furthermore, when addressing the Maori question, the Treaty Principles Bill mirrors critiques from its white American counterparts regarding diversity, equity, and inclusion, called DEI. For example, a charge from white Americans about a DEI hire. Our policies suggest that unqualified individuals are given opportunities based on race or gender instead of merit, competence, or qualifications. Likewise, similar to the white US president who attributed a January 29, 2025 air disaster in Washington, DC to DEI initiatives, despite 4 of the 5 pilots and co-pilots being white, the sponsors of the Treaty Principles Bill suggest that the 1975 Waitangi Treaty Principles are like a DEI policy and therefore responsible for material inequalities, such as differing ticket prices for concerts. Finally, in promoting the Treaty Principles Bill, its sponsors are unclear about how equal rights or equality for all relates to merit or qualifications. They assert or assume that inequality will disappear. We know this assertion or assumption is unfounded. In countries like the United States, where, quote, equal rights and the rule of law, unquote, are claimed to be upheld, nearly all recent nominees for high-level government positions show that merit, competence, and qualifications played a minimal role in their appointments. However, they share the following lowest common denominators. They are mostly white, and they have pledged loyalty to a white president rather than to the rule of law. Alarmingly, this mindset permeates the talking points of the bill sponsors, which is why the treaty principle bills must be rejected. Thank you.
Kia ora, Edward, and thank you for your perspective from Indigenous North American people, one that we haven't yet heard. So thank you for that, a unique perspective. We don't have any time left for questions, but thank you for taking the time to have your submission, which we've read and present it orally. So thank you.
Thank you.
Members, our next submitter is Jason Boberg. Kia ora, Jason. Good to see you. We've got you here for 5 minutes, and we've got your written submission in front of us. So I'll hand straight over to you to speak to your submission.
Kia ora koutou. Thanks very much. My name is Jason Boberg, and I'm a proudly disabled person and tangata tiriti. Thank you for the opportunity to present orally today, but I would like to note briefly how inaccessible this process is, specifically with the lack of sign language interpretation or live captions, excluding a large group of deaf and disabled Kiwis from participating in the democratic process. My family is originally from England, Scandinavia, and Lithuania. Because of Te Tiriti, I had the privilege to grow up in Tamaki Makaurau, and now live on Ngati land in Ototahi. I'm also a small business owner and work in the field of advising and navigating systems change and complex problems. Core to my work is, of course, progressing rights for disabled people, particularly in the face of climate change, which has included advocating in multiple UN bodies for our rights and equitable outcomes. While the technicalities of international agreements and mechanisms aren't the focus of my personal submission, I would like to note that the bill itself is a breach of Te Tiriti and UNDRIP and many other human rights principles that New Zealand is assigned party to, and I'd like to echo the submissions made by Te Runanga o Ngāi Tahu and the Human Rights Commission. One side of my family immigrated within living memory. When my mother was still a child and my grandfather coming to Dunedin with his family to take up a job as a surgeon, a somewhat remarkable place to find himself considering that his grandfather and family had dispersed around the world fleeing hatred and war that was about to sweep across Europe during his time. My grandfather found his home here because of our unique cultural values, especially around service care and manaakitanga. These aligned with his values, and he was able to implement them throughout his work and life. He went on to contribute greatly to the place he called home and received the highest civil honour for his service to thoracic surgery and palliative care in New Zealand. It is Te Tiriti that enabled my ancestors to be here, and myself, and for some of my ancestors it provided a new beginning, and for others a place to call home after generations of searching. The complex nature of summarizing the impacts of 180 years of jurisprudence, international agreements, and what is part of our founding constitutional arrangement, Te Tiriti, does take time. As we say in the industry, a complex problem requires a complex solution. However, the problem here is not Te Tiriti. Te Tiriti is and always has been this solution. It brought two peoples together, keeping the rights of Māori and establishing how the Crown could maintain itself. This agreement was not honoured by the Crown, and has taken generations of advocacy and maturing as a nation to begin to address these breaches. This is the importance of the establishment of the Waitangi Tribunal and our judicial system, in part to help give redress to these grievances. The real problem we are facing today is that the Crown through this bill is seeking to once again undermine Te Tiriti. The problem is that this bill hides misinformation behind a veil of simplicity and equality, but chooses to ignore the complex reality of a system that the Crown has created, and that enables it to exist on this whenua. It's a one side of a two-party agreement, changing the agreement without consultation or renegotiation with the other party. Imagine what would happen if businesses took lead from this bill in their agreements, or if New Zealand treated its international partners this way. The simple solution here is that we already have an agreed upon process. We already have a treaty that allows everybody to be here. We already have 100 years of well-versed jurisprudence across the spectrum of law, which directly supports how this works. And we all know what it means to be Kiwi. We collectively know that this bill does not align with our values. Because of this, I oppose the bill and request the Select Committee not to let it get any further. Finally, when I'm thinking about my family history and the history of our nation, And what I'd like to tell our next generation about this time is that we're all here in good faith, with a vision that was set and fulfilled through Te Tiriti, that has resulted in this fantastic country of ours. And it was just for a brief time that an incredibly small, uninformed minority got more than their fair share of democracy. But unlike the hatred and division that this nation has seen, and the hatred and division that consumed my grandfather's homeland, we collectively chose to stand together and acknowledge that upholding Te Tiriti was indeed the right path. And that's something that I know my ancestors would be proud of. Kia ora.
Kia ora, Jason. Thank you for your submission. We're pretty much out of time, so we don't really have any time for questions, but we'll leave it there. And thank you for your written submission, which was very useful as well. So, kia ora, ka kite. Members, our next submitter is Ihapera Paniora.
Kia ora, can you hear me?
Kia ora, Ihapera. Good to see you. We've got you for 5 minutes, and we've got your written submission here in front of us. So I'll hand straight over to you. Kia ora.
Kia ora. Tēnā koe te rangatira Pash, tēnā koutou Duncan, Jamie, Carl, me rima, Ihapera Paniora tuku ingoa, he uri o no Ngati whātua, Ngati wai me Ngāpuhi. I lodge my submission in my own right as an uri of Parore Te Awha, who was one of a select few rangatira who signed both he whakaputanga o rangatiratanga o Nūtirini and Te Tiriti o Waitangi. 42 years later, he funded an unsuccessful expedition to Queen Victoria demanding a royal commission to investigate laws contravening the treaty and asked for authority to establish a Māori parliament. I do not give mana to this bill, but my whakapapa forces me to be here today. I concur with a lot of the concerns raised by prominent rōpū and have personally viewed many submissions made by members of my community. I just want to quickly set out the historical context as I understand it to be. On 28 October 1935, 34 leaders assembled to declare the authority and leadership of this country to be the prosperous economy and chiefly country under the title of the Sacred Confederation of Tribes of New Zealand. This is when He Whakaputanga became the constitutional document ensuring our independent sovereignty, as was declared. It was a precursor to Te Tiriti o Waitangi. And so on 6th of February 1840 and in the months that followed, over 540 chiefs signed Te Tiriti o Waitangi, whilst only 39 chiefs, predominantly from the Waikato, signed the Treaty of Waitangi. The Waitangi Tribunal confirmed in Te Paparahi o Te Raki that sovereignty was never ceded. Te Tiriti o Waitangi is therefore an international agreement between two sovereign nations. So I wonder, how can a party with only 6.4% of the vote for only a mere 3 years introduce such a treacherous bill that attempts to rip apart the very core of our Constitution and to determine unilaterally and retrospectively what the constitutional arrangement should have been? And how is it democratic for them to do all of this without even the support of their coalition partners who have said, and I quote, "You do not negate with a single stroke of a pen 184 years of discussion." The new version of partnership is a blatant rewriting of Article 1 itself. It even mischaracterizes the definition of the word itself. Partnership is not one party forcing its beliefs on another. The new version of protection is much the same. It theorizes that all Māori know their hapu and iwi, and that all treaty rights and obligations have protections already in place within the current legal framework. This couldn't be further from the truth. And the new version of participation uses the word discrimination because ACT has already set about reinterpreting special rights of Māori as discriminatory and racist, when they are no different from the differing rights each independent nation provides its own citizens. There are fundamental issues at play, including that the bill goes far beyond introducing principles used to aid in interpreting Te Tiriti o Waitangi and instead redrafting them unilaterally, and the mechanism to trigger a referendum when the general public is not positioned to understand the complexities of what is being proposed, nor are they party to the treaty. It is also a foregone conclusion that the referendum will skew in favour of non-Māori because Māori are the minority. It is correct to say that the treaty principles have never been defined because they are just that, principles that can be applied to a multitude of situations and circumstances to arrive in an outcome that is tika. This is very normal in legal context, for example, the rule of law. Our constitutional arrangements are set out in various pieces of legislation, judgments, guidelines and conventions, including the Bill of Rights Act 1990, providing all New Zealanders with most of the rights restated in this bill. This bill therefore undermines the founding constitutional documents of Aotearoa New Zealand that our tupuna set and agreed upon for the foundations of a peaceful Aotearoa. It does so by unilaterally altering the purpose, the context, definitions and agreements that were reached. For example, it alters Article 2 so that instead of Hapu and iwi being able to exercise rangatiratanga over their lands, villages and treasures, it will only be recognised if it is in legislation, treaty settlements or other agreements of the Crown.
I'm just going to let you know, you've only got about 20 seconds left, so you probably need to wind up.
This has the effect of splitting us into tribes and removing our collective rights and duties as iwi Māori. The Waitangi Tribunal and the courts continue to be the appropriate mechanism to determine disputes arising between Māori and the Crown, and in everyday settings we are able to apply the current treaty principles to our everyday lives. For example, as a Te Ata Kure Tiriti educator, we equip participants with the resources to honour Te Tiriti o Waitangi and apply the principles to their specific roles. In closing, I am strongly opposed to this bill. It breaches Te Tiriti and the United Nations declarations on the rights of Indigenous peoples. It highlights the need for our founding documents to be written into our constitutional arrangements so that we never have to be in this position again as a nation and as a country. I implore the Select Committee to honour our collective shared history, and I hope that I have held the mana of my tupuna intact. Kia ora.
Thank you for that, really articulate submission, and I've read your written submission as well, really well put together. So, no, Mihi, thank you for that, and thank you for taking the time to present.
Ngā mihi.
Members, our next submitter is Manaaki Tangata, Victims Support, and we have them for 10 minutes. Kia ora, good to see you. Welcome to the subcommittee of the Justice Select Committee, and we've got your written submission in front of us. We've got you here for 10 minutes, including any questions. So if it's okay with you, I'll hand straight over to make the best of that time.
Kia ora, tēnā koutou katoa, ko James McCulloch Tokawingwea. I'm the CEO of Manaaki Tangata Victims Support, and I'm joined by Patrina Hargrave, our GM of Strategy and Advocacy as well. I'll let her introduce herself.
Kia ora katoa, ko Patrina Hargrave Tokawingwea. I'm the GM of Strategy and Advocacy at Victim Support.
So we're pleased and honoured to present to you today on behalf of Manaaki Tangata Victim Support. We are an organisation of many people, volunteers across the country and staff, and we've supported hundreds of thousands of New Zealanders through crime and traumatic events over the past 37 years. Our support is free, it's available to everyone, and it can be accessed 24 hours a day, 7 days a week. And we know that what we do is incredibly life-changing. We know this because our clients tell us, and we see the pride that we feel from our teams across the country and from successive research reports nationally and globally that speak of the importance of our work. And as Chief Executive of Victim Support, and actually several other social support agencies here and overseas, I truly believe that the measure of a great country and a great community is how we support those going through tough times. And victims of crime certainly are going through tough times. Now, our mission is to ensure that all victims of crime feel safe, they feel welcome, and they feel empowered to use our services. But achieving this requires so much more than just treating everyone the same. It requires us to understand the unique challenges different communities face and how we adapt our support accordingly. And that's why Te Tiriti o Waitangi is so important to our work. It provides a framework for equity. It guides our people to meet them where they're at, and it ensures that our support is truly accessible to everyone. So today, we're here to express our strong opposition to the Treaty's Principles Bill, because abandoning equity for equality would undermine our ability to serve all New Zealand crime victims effectively. That's not just a matter of semantics, it's about justice and safety for everyone.
And why is ōrite equity so important in victim support? Well, Maori make up 17% of the population, yet 34% of victims of crime. 5% of Maori adults experience 81% of all violent interpersonal offences and 56% of burglaries. So there's no equality in these numbers. So how can we possibly solve this problem by treating everyone the same? Maori are not overrepresented as victims by chance. Colonisation, breaches of te tiriti, and systemic discrimination have created intergenerational trauma, economic hardship, and social exclusion. These factors not only make Māori more likely to be victims of crime, they also create barriers to accessing support and engaging in the justice system. And with distrust of the New Zealand justice system, only 1/4 of crime is currently reported. We need to put every effort into better supporting victims, both for those who report crime and those who don't, particularly Māori victims. And as being a victim once is a major predictor of being a victim again, 18% of Māori victims are repeat victims. Organisations like Manaaki Tangata Victim Support play a vital role in preventing further harm.
What we also know is that supported victims are safer victims. Supported victims are more likely to engage in the criminal justice system, which means offenders are more likely to be brought to justice. Put simply, organisations like Victim Support have a vital role to play in secondary crime prevention. But we don't achieve this through equality. This simply doesn't work in any social support sector I've experienced or led here or overseas. It certainly doesn't work in victim support. Treating everyone the same ignores the impact of the past on the present and assumes everyone starts at the same point. I guess it's like expecting all runners to finish a race at the same time because they all wore the same shoes. This approach would therefore fail Māori victims. It would ignore historical and systemic barriers, deliver a one-size-fits-all service that doesn't match needs, and it would actually erode trust both in our organisation and in the justice system. In fact, we would be perpetuating the very inequities that we aim to address. But the impact wouldn't just stop there. If Māori victims don't engage with support services due to cultural insensitivity or distrust, they are more likely to suffer in silence and face repeat victimisation as well. And when perpetrators are not held accountable, they remain free to harm others, risking higher victimisation rates across all communities.
We're extremely fortunate to have Te Tiriti o Waitangi and its principles as our guide. So at Victim Support, we turn to the principle of ōrite equity, to anchor our work and help us address the harm and injustice that we see every day. But it goes even further than that. It inspires our ambition to keep growing and evolving how we offer support so that people of all ages, all backgrounds, all experiences feel safe, welcome, and empowered to accept our support. In fact, at Victim Support, we place Te Tiriti at the heart of our work, making it one of our 3 core guiding principles. So we're victim-centric, trauma-informed, and Te Tiriti-led. And these principles are interrelated. You can't claim to be victim-centric in New Zealand unless you're also trauma-informed and Te Tiriti-led, because understanding Māori victimisation requires us to understand the factors, including intergenerational, historical, and state trauma that contribute to Māori victimisation in the first place.
And this isn't just a statement, it's actually a huge commitment for us. And for several years now, all our staff have been required to complete extensive training on Te Tiriti o Waitangi and its relevance to our sector and to our work. As a mainstream organisation with a predominantly Pākehā workforce and indeed a Pākehā leader, this training has been transformative for our organisation. It's opened our frontline's eyes to a whole different worldview. It's revealed the potential for unconscious bias, and it's clarified the difference between equity and equality. And this doesn't just enhance our work with Māori victims, it improves our support for all victims who are different from our support workers. And in a country where marginalised communities, including rainbow and disabled people are also disproportionately affected by crime, the principles of the treaty also provide a vital lens for all our work. In fact, in a world that's unequal, these principles promote understanding and empathy, helping us build a more just and inclusive society. And as a mainstream organisation, we still have so much more work to do. In fact, we're appointing a GM Maori right now to build and enhance relationships with Hapu and iwi and our kaupapa Maori agencies. Our aim is to ensure that Maori feel safe to come to us and supported when they do so. And we're making huge progress in better supporting victims, but we have a huge, long way to go.
Let's not undo this progress. We, as leaders of victim support, appeal to you, as leaders of the country, to embrace our collective responsibility to ensure all New Zealanders understand why equity rather than equality is the solution. Acknowledging our current treaty principles does not create special treatment for Māori victims. It creates fairness. Different groups need different support to achieve equal outcomes. Just as ramps and elevators ensure disabled people can access the same buildings as everyone else, culturally tailored victim support services ensure that Māori can access the same justice and healing as everyone else. That is fairness, and fairness is the cornerstone of justice. If we truly believe in justice for all, then we must uphold the treaty principles that ensure culturally appropriate support for Māori victims. Only then can we achieve a fair and safe New Zealand for everyone. Ōrikitanga is not just a principle, it is a lifeline for those who have been harmed and a safeguard for the future of our communities. For the sake of all victims and for the safety and well-being of our nation, it is vital that we continue to uphold it.
So to conclude, a justice system that fails Māori victims is a justice system that actually fails all New Zealanders. Weakening treaty principles won't create fairness. It may in fact create more victims, more crime, and a less safe society for everyone. And if we're really serious about justice, then we must stand by the principles that ensure culturally appropriate support for Māori victims. Only then can we achieve a fair and safe New Zealand for all. And so, in closing, we urge the committee to consider the real-world impacts of the bill, not just on Māori victims, but on the safety and well-being of all New Zealanders. Thank you for your time, and thank you for your consideration. Nō reira, tēnā koutou, tēnā tātou katoa.
No, Mihi, thank you for that. We are pretty much out of time, but if any member had a short question, we could put it. Scott.
Thank you. Thank you both particularly for raising the question of fairness. We've heard from many people how offensive this bill is, and you've outlined how it will increase harm. And one submitter talked about the importance of a Crown apology to acknowledge the egregious breach of Te Tiriti o Waitangi that is this bill. What do you think about the importance of a Crown apology just for this bill to start to repair that harm?
I'll make a start and hand over to Katrina in a moment. Look, I think that anything from our point of view that encourages more people to feel safe coming forward to an agency like ours, that despite our independence is aligned with other agencies, is aligned with the police as well, we would welcome that. Anything that can try and undo some of the strength of feeling and challenges that we've seen in the last few weeks and months, because we see that playing out amongst our frontline support workers right now, and we're working hard to alleviate that, but we welcome anything that would help.
I'll just add that given that Māori are overrepresented as victims of crime and breaches of Te Tiriti are a known reason for their over-victimisation, and that this bill, we believe, is another breach of Te Tiriti, I think that an apology specific to Māori and Māori crime victims would be very well received. Kia ora.
All right. No, Mihi, we've really got to leave it there. We're over time. But can I just thank you for the work that you do, and thanks for taking the time to make a really useful submission. Kia ora.
Kia ora.
Members, our next submitter is the New Zealand College of Midwives, Waitaha and Hitai Putini regions. And I can see we've got Becky Bangma, I think, online to submit. So, Becky, we've got you for 10 minutes, and I'll hand straight over to you to make that best of that time.
Right, kia ora koutou. Can you hear me okay?
Can.
Yeah, perfect. Thank you for the opportunity to submit today. My name is Becky Bangma, and I am the chairperson of the New Zealand College of Midwives, Canterbury West Coast region. Our membership is made up of over 600 midwives, student midwives, and consumers across our regions. I have practiced as a community midwife for 6 years and have been employed in the hospital setting for the past 2 years. As a region, we would like to express our strong opposition to the Treaty Principles Bill due to the potential negative and inequitable implications to birthing people and their relationships with midwives and the broader health system. Over the past 2 years, I have started my own journey of awareness, recognising and understanding my conscious and unconscious bias, racism, and white supremacy. I've had a very limited understanding of Te Tiriti o Waitangi, due in part to the bare minimal and whitewashed education I've received during my schooling and undergraduate study. I now have a deeper appreciation for Te Tiriti and its intention to uphold and protect tino rangatiratanga and the responsibility for political control to remain by Māori for Māori. Before our last election, as midwives, we have seen more community cohesion, improving relationships and partnerships between our Crown health system and Māori. This has meant we have been able to learn alongside Māori about a more holistic, inclusive, equitable, less cookie cutter model of care. This model has benefited all communities we care for. Even the idea and proposal of the Treaty Principles Bill has caused pain, mistrust, distress and anger throughout the maternity and wider healthcare system, starting to unravel the work and cultural understanding that had started to blossom. The disestablishment of Māori health initiatives and the seemingly deliberate lack of any sort of equity lens being placed over new health initiatives in our region has pushed this progress back further and created even more division. How are Māori, and in fact any non-European whānau, supposed to trust in a health system that continues to repeat historical injustices? Looking to Te Tiriti and its intentions and not the Treaty Principles Bill supports us to strive towards equity, which means healthier and empowered whānau and pepe. As a tangata Tiriti woman and midwife, I cannot speak of how I have faced inequities because of the colour of my skin, or how I have been disadvantaged within the healthcare system. What I can speak to are the inequities, bias and racism that already exist and I have been witness to in our maternity system. These are far-reaching and damaging, not only for whānau, but to the healthcare provider and midwives that care for them. The Treaty Principles Bill could lead to, quote, Māori cultural elements being superficially added to care practices or policies, but without meaningful engagement or respect for the underlying principles. This superficial engagement will lead to frustration and mistrust, further deepening cultural divides, bias and racism. Whānau navigating our maternity system might feel that their culture is being used for cosmetic purposes, not genuinely respected, leading to further feelings of alienation and a loss of their birthing practices and mana. This will in turn lead to a breakdown of trust between midwives and whānau by introducing ambiguity around the legal status and rights of birthing people, particularly on the context of their health, reproductive and birthing choices. For birthing people, the ability to make informed, autonomous decisions about their care is essential. One of the most fundamental aspects of New Zealand's world-renowned and respected midwifery model of care is the collaborative and trusting relationship between birthing people and their midwives. The introduction of a framework that emphasises disproportionate authority or power in the interpretation of treaty principles could erode this autonomy, leading to uncertainty in how midwifery and maternity care is delivered. Midwives could be placed in a position where they must navigate complex legal and ethical obligations based on the evolving interpretation of treaty principles, potentially complicating and damaging this already sensitive nature of pregnancy, childbirth, postnatal care, and the whānau voice within this. The writers and supporters of this bill, I believe, are relying on a limited understanding, like my own, of Te Tiriti o Waitangi and its intentions in healthcare, alongside a misunderstanding and underappreciation for the significant differences between equality and equity. Do we want equal treatment for all, regardless of circumstances, as the bill outlines, or do we want fair outcomes by addressing differences in needs? Do we want the same level of care and resources for everyone, as the bill outlines, or do we want to ensure all individuals have the same opportunities for healthcare? This is the difference between equality and equity in healthcare. The Treaty Principles Bill and its focus on equality has the potential to manifest as unequal access to midwifery and maternity care or varying standards of care depending on how healthcare providers interpret the principles. This is especially concerning in the context of already existing health inequities, where Māori and other marginalised groups experience poor health outcomes due to systemic and unequitable barriers. The recently released 16th annual report of the Perinatal and Maternal Mortality Review Committee and its key findings are a heartbreaking and raw example of inequities and their consequences. Ethnicity, deprivation, and age inequities persist across perinatal and maternal mortality. There continues to be worse outcomes for babies with Indian, Māori, and Pacific heritage compared to New Zealand European birthing people. The overall annual perinatal mortality rate has not significantly decreased in the period 2007 to 2021. Over the period 2006 to 2021, Māori and Pacific peoples have over twice the rate of maternal mortality compared to the group with the lowest, European. If the Māori and Pacific mortality rates were the same as the European rates, overall maternal mortality in Aotearoa, New Zealand would be 30% lower. Suicide remains the leading cause of maternal death in Aotearoa, New Zealand, accounting for over 40% of direct maternal mortality events. Over the period 2006 to 2021, Wahine Māori had over 3 times the suicide rate of New Zealand Europeans. As stated in the report, the health system in Aotearoa must ask itself why, compared with the European population, Māori have a 43% higher chance of perinatal-related mortality from infection. Pacific peoples have double the mortality from hypertension and Indian populations have an 84% chance of mortality from antepartum hemorrhage. This discussion should be uncomfortable, but will result in opportunities to save lives. A maternity and wider health system that identifies the risks and develops systems to address those risks will improve outcomes. How will the Treaty Principles Bill address these with a focus on equality and not equity? I would also like to address the potential impact on Māori midwives within our region with the implementation of this bill. As a Tāwaiwi midwife, I do not wish to speak for my tangata te whenua colleagues, but with the support of our colleagues of our region's Māori midwives ki tahu and conversations with midwives within our region, I'm implored to shed light on these implications. These impacts primarily concern the balance of cultural expectations, professional challenges, and systemic issues, including an increased workload and responsibility with added expectations on Māori midwives to lead or be responsible for integrating Māori cultural practices within healthcare and maternity care. This may include having to ensure that care for Māori birthing people aligns with both the Treaty Principles Bill and Māori cultural values. This could lead to an increased workload, particularly if Māori midwives are expected to take on roles as cultural leaders or advisors within the healthcare system, leading to further burnout, which already affects many midwives in our community. There is a potential for tokenism, where Māori midwives are expected to represent Māori culture in a symbolic or superficial way without real institutional support or resources. This could create situations where Māori midwives are overly relied upon to address cultural needs without the necessary training, time, or resources to do effectively. The Treaty Principles Bill could raise cultural expectations that might conflict with professional boundaries, leading to tension between the need to provide culturally competent care and the clinical demands of midwifery practice. Māori midwives may face pressure to balance these cultural expectations with clinical practices that are not always aligned. This can create a difficult dynamic where midwives feel torn between representing their cultural values and adhering to medical or institutional protocols. Māori midwives may face under-recognition or lack of support for the unique skills and knowledge. The healthcare system might prioritise Western medical knowledge over Māori traditional practices, potentially undervaluing the expertise that Māori midwives bring to their practice. As I mentioned earlier, bias and racism are already present in our maternity and healthcare system. The Treaty Principles Bill will increase tensions between Māori and non-Māori healthcare workers, as well as among different ethnic groups in the broader healthcare system.
Vicky, I'm just going to interrupt you, let you know you've got about 30 seconds to kind of wind it off.
Great. This could lead to further division within the healthcare workforce, weakening collaboration and creating a less supportive working environment. In conclusion, on behalf of the Canterbury West Coast region of the New Zealand College of Midwives, I strongly oppose the Treaty Principles Bill in its current form. Its potential to undermine the relationship between birthing people and midwives, introduce unnecessary complexities, and exacerbate inequities in the healthcare system cannot be overlooked. We urge policymakers to reconsider this bill and focus on measures that will promote equity, accessibility, and cultural safety in healthcare while protecting the autonomy of birthing people in New Zealand. Ngā mihi nui.
Kia ora, Becky. Thanks for your submission, and thanks for your written submission, and also all the work that you and your colleagues do, of course. So thank you for that.
Thank you.
Members, that brings us to a conclusion of this morning's submissions. We are returning at 12:45. It'd be great if you could be here a moment early so we can get off promptly. So kia ora, and I'll see you back in a little under half an hour.